Very well. The next item of public business is the draft children arrangements to assist children to live outside Jersey, Amendment Jersey Law P9. The main respondent is the chair of the Children Education and Home Affairs Scrutiny Panel. I ask the greffier to read the citation.
Draft children arrangements to assist children to live outside Jersey, Amendment Jersey Law 2000, a law to amend further the Children Jersey Law 2002. The state, subject to the sanction of a more Excellent Majesty and Council, have adopted the following law.
Yes, Minister.
Thank you, sir. So, the Children Jersey Law 2002 contains provisions to allow the Minister for Children Education to look after children where there is a need under certain defined circumstances. In a small number of cases, this will mean an off-island placement is required. One of the safeguards built into this law is a requirement under paragraph 4 of Schedule 2 for the Royal Court to approve such any off-island placement. This amendment is being sought in response to a recent case in which the Royal Court recommended that the Minister reviews paragraph 42C2 of Schedule 2 of the Children's Law in order to clarify what was meant by the term suitable person. The current lack of clarity means there is a potential discrepancy between the conditions put on an application in respect of a child who is able to consent and a child who is unable to consent to an off-island placement. The court's view is that this served no practical purpose, and the term suitable person was also unhelpful in deciding on placements when the best placement may in fact be residential. The amendment seeks to implement the court's recommendation and remove the term suitable person from the schedule. This would remove the anomaly but leave the requirement for the court to approve these placements and arrangements for children unaffected. For the avoidance of doubt, the proposed amendment does not seek to change the role of the court in approving an off-island placement, and the amendment is not about lowering the bar to off-island placements. In fact, since 2019, sir, the overall trend for children placed in an off-island placement has steadily reduced. The current wording of the schedule has created uncertainty, and it runs the risk of delay in decision-making on placements, which evidence shows is likely to be harmful in terms of the experience and outcomes. In substituting a revised paragraph 2C for the existing provision, the amendment will resolve this technical issue in this respect. So I propose this proposition to the Assembly in first reading.
Thank you very much. Deputy, is it seconded for first reading?
Yes, sir.
Does any member wish to speak to the principles? No member wishes to speak to the principles. Deputy Ward.
Thank you, sir. I feel I should speak from the panel because we did raise the issues that may have arisen regards the lowering of the bar for off-island placements, and we were concerned and went through the process of talking about the suitable person phrase and went down the, how can I explain them? I think once you get into the discussion, you end in what one might call a number of rabbit holes around that phrase, and I can confirm that we explored all of those and came back to a point where I think we are clear that we're pretty certain this does not lower the bar, it does not change the process, and may actually be more appropriate, and we hope that is the case. But I think, sir, the panel would also say that I'm sure, as with the Minister and with this Assembly, we want to see the continued trend of less off-island placements continue until there's a point where we would hope they aren't necessary at all, because the best place for children is, first of all, with their family, and second, in their community. So with that, sir, I think just those brief comments before we move forward. Thank you, sir.
Does any other member wish to speak on the principles? No other member wishes to speak on the principles? Then I close the debate and call upon the Minister to respond.
Thank you, sir. And can I thank the Deputy and his panel as always, for their hard work, the time they put in, their strong challenge at every aspect of the laws that they scrutinise for me. And it is very much appreciated. So I would like to thank the scrutiny panel. They always do a sterling job, sir. And with that, can I ask for the vote and the appel, please, sir?
Well, I invite members to return to their seats. And I ask the greffier to open the voting. The vote is on the principles of P9. If members have had the opportunity of casting their votes, I ask the greffier to close the voting. The principles have been adopted. 37 votes pour, no votes contre, no abstentions. Does your panel wish to call the matter in, Deputy?
No, thank you, sir.
How do you wish to deal with the matter in second reading, Minister?
Can I just do them en bloc, please, sir?
Yes, are the articles seconded for second reading? Does any member wish to speak on any of the articles in second reading? No member wishes to speak? Then I close the debate and ask the open the voting. Ask the greffier to open the voting. If members have had the opportunity to cast their votes, then ask the greffier to close the voting. The articles are adopted in second reading. 37 votes pour, no votes contre, no abstentions. Do you propose the matter in third reading, Minister?
Yes, please, sir.
Is it seconded for third reading?
Yes, sir.
Does any member wish to speak in third reading? If no member wishes to speak in third reading, then I close the debate and I ask the greffier to open the voting. If members have had the opportunity of casting their votes, then I ask the greffier to close the voting. The law has been adopted in third reading. 38 votes pour, no votes contre, no abstentions. The next item of public business is the draft trademarks, registered designs and panels application forms, Jersey Regulations P11, lodged by the Minister for External Relations and Financial Services. The main respondent will be the Chair of the Economic and International Affairs Scrutiny Panel, and I ask the greffier to read the citation.
Draft trademarks, registered designs and patent application forms Jersey Regulations 2000. The states make these regulations under Article 31A of the Trademarks Jersey Law 2000, Article 20A of the Registered Designs Jersey Law 1957, and Article 24A of the Patents Jersey Law 1957.
Minister.
Thank you, sir. Sir, members will be aware that External Relations and Financial Services has responsibility for 3 laws in Jersey making provision about intellectual property rights that arise as a result of registration. Sorry, I apologise. These are the Trademarks Jersey Law 2000, the Registered Designs Jersey Law 1957, and the Patents Jersey Law 1957. These laws essentially provide for re-registration in Jersey of intellectual property first registered in the United Kingdom. The person who is the proprietor of the right in the UK is the person who can apply for registration in Jersey. The judicial greffier is the registrar for whom an application must be made, with the register of rights maintained at the judicial greffe. So under the trademark law, it falls to the minister to prescribe by order the manner in which an application for registration in Jersey must be made.
Please put it all together now.
If anyone who is not within the assembly could please check that their microphone is switched off, because we're receiving unwanted interference. Please do carry on.
Thank you, sir. So the Trademarks Jersey Order outlines how applications for registrations must be made. The order also contains the relevant application forms that should be used. So the process under the Registered Designs Law and Patents Law is different, as the responsibility to prescribe the manner in which an application must be made currently rests with the superior number of the Royal Court. The Registered Design Rules 1958 and the Patent Rules 1982 prescribe the manner of application and contains the relevant application forms. As a result of the current legal framework, any time an amendment is needed in one or more of the application forms, including the trademarks order, however minor, there is an administrative procedure of making order changes that needs to be completed. Similarly, if application forms are included in either a set of rules of court needed to be updated, the procedure set out in the Royal Court Jersey Law 1948 must be followed. So I believe that there are disproportionately cumbersome procedures for making such and often minor and non-substantive administrative changes. Therefore, sir, to enhance the flexibility under the current relevant legal provisions, my minister is bringing the draft trademarks, registered designs and patents application forms Jersey regulations to the states. Excuse me, sir. The draft regulations would amend the current legal provisions that deal with the manner of application for registration in Jersey under each of the 3 intellectual property laws. More specifically, the draft regulations are intended to allow the judicial greffier to specify the manner of application by publishing a notice or form on a website. That would replace the current requirement for static paper-based forms to be prescribed by a ministerial order or by rules of court, thereby enhancing the flexibility under the 3 laws. So if these regulations are approved, the process to have made trademarks and patent rules and registered design rules will be set in train by a responsible office, in particular with a view to removing the current outdated forms. Once this process is finalised, any future changes with regard to the manner of application will be for the judicial greffier to decide on and publish without the need to bring further legislative changes. So for the avoidance of doubt, these regulations, if passed, will make no changes to the substantive legal provisions in any of the 3 laws that regulate applications for regulation in Jersey. The information and documents that applicants must provide remains unchanged, and the judicial greffier will need to ensure that those requirements are reflected appropriately in any forms that may be published. So in short, sir, it means that people can apply online rather than having to fill out detailed paper forms. And as such, sir, I move the principle.
Very much. Are the principles seconded?
Indeed they are, sir.
Does any member wish to speak on the principles? No member wishes to speak on the principles? Then I close the debate, invite members to return to their seats, and ask the greffier to open the voting. If members have had the opportunity of casting their votes, then I ask the greffier to close the voting. The principles have been adopted. 37 votes pour, no votes contre, no abstentions. Deputy Sir Mary, does your panel wish to call this matter in?
No, sir, we're content with that. Thank you, sir.
Very much indeed. How do you wish to deal with the matter in a second reading, Connetar?
So I would ask, there are three sets of regulations for each law, but I would ask that they're all designed to achieve the same end, and I would ask that the members take these en bloc. Naturally, I'm happy to ask questions as they arise.
Very well. Are they seconded in second reading?
Yes, sir.
Thank you. Does any member wish to speak on any of the articles in second reading? If no member wishes to speak in second reading, then I close the debate and I ask the greffier to open the voting. If members have had the opportunity of casting their votes, then I ask the greffier to close the voting. The articles have been adopted in second reading. 38 votes pour, no votes contre, no abstentions. Do you deal with the matter in third reading?
Please, sir. And before we proceed to the third reading, if I could just thank Deputy Sir Mary and his panel for their input, which is invaluable as always, sir.
Indeed. Is the law seconded for third reading?
Indeed it is, sir.
Does any member wish to speak in third reading? If no member wishes to speak in third reading, then I close the debate and I ask the greffier to open the voting. Members have had the opportunity of casting their votes. I ask the greffier to close the voting. The law has been passed in third reading. 39 votes pour, no votes contre, and no abstentions. Before moving to the next item of public business, I would just like to notify members that a proposition brought by Deputy Pershard has been lodged, and she will in due course be seeking permission of the Assembly to have it taken during the course of this sitting. Members will hopefully have seen it, but if not, it will be circulated shortly. It relates, of course, to the Ukraine and questions of immigration and of that nature. Well, Deputy Pershard, I would suggest that we review at the end of the day whether the Assembly will be wanting to make a decision as to discussing the matter tomorrow, or if we reach it at the end of the day, well, then you'll have to make your proposition at that point.
Thank you, sir.
Very well. The next item is states-owned bodies, accreditation as living wage employers, P14 lodged by Senator Mezek. The main respondent will be the Minister for Treasury and Resources, and I ask the greffier to read the citation.
The States are asked to decide whether of opinion to request the Minister for Treasury and Resources in her capacity as shareholder representative to inform those incorporated bodies of which the States of Jersey is sole shareholder or majority shareholder of the Assembly's intention that they should seek accreditation as living wage employers by the end of 2022, and to take such measures as are necessary to urge and assist these bodies to achieve this.
Senator.
Thank you, sir. I am hoping that this can be a relatively short debate on the basis that this asks the Assembly to endorse a position which has already been endorsed by the Assembly in the beginning of January 2022, in that we would like all of the government-owned companies to become accredited living wage employers and sign up to everything that goes along with that. But this time round we're setting a deadline, because it is the case that we asked for this to happen way back in January of, way back in 2018, and there are some companies which have not yet gone through that process. Some have, and it's very pleasing to see that. JT, States of Jersey Development Company, Jersey Electricity, certainly I know they have. I know that Andium and the Ports of Jersey were looking to seek accreditation, but in adopting this proposition, we give a very clear signal to all of the government-owned companies that becoming living wage employers is something we would like them to do, and would like not just their employees, but the employees of those who they contract with to benefit from this as well, and hope that that behaviour of ensuring that you pay your workers enough to live on permeates throughout the rest of the economy, in the absence of this Assembly choosing to set the minimum wage at the living wage rate, which is obviously what I would prefer. There isn't a huge amount more to say on it other than that, so this is a very short opening speech. I hope it won't be a contentious item, and that we can send that message to those government-owned companies that by the end of this year, having agreed to have done it 4 years ago, has been quite enough time. So I make the proposition, sir.
Thank you very much. The proposition seconded. Minister.
Thank you, sir. I wish to say from the outset that I'll be supporting this proposition. However, I do have to address some of the points the Senator has asserted in the report accompanying his proposition. The Senator references Deputy Southern's original proposition, which requested the Minister for Treasury and Resources to, quote, urge those incorporated bodies of which the State of Jersey is sole shareholder to seek accreditation as a living wage. Members should be assured that these 5 wholly owned entities were so urged. The proposition before us now extends this to include the majority owned entities and to not only urge, but to assist these entities to obtain living wage accreditation. It could be inferred from this proposition and reference to my response to oral question 2, 2022, that I only confirmed that JT, Jersey Telecoms, and the States of Jersey Development Company were already accredited, and that Andium and Ports of Jersey were working towards accreditation in 2022. Sir, there is only one other wholly owned body, Jersey Post, and the original question did not reference majority-owned states companies. However, in my response, I did confirm that all wholly owned states entities pay their staff at least the living wage, and many of them above it. I hope members will allow me to make the position clear. Of the 7 states-owned entities, 3 are already accredited, including Jersey Electricity, and 3 are working towards it this year. So the overall tenor of the report is that it is a simple process to be accredited, but I'm afraid that the Senator underestimates the process, which brings me back to Jersey Post. They, I understand, have met with the Senator and have sought to explain that the accreditation process is by no means straightforward. This is particularly relevant when you have overseas subsidiaries, notwithstanding the fact that all Jersey-based employees are paid above the living wage. Jersey Post are, however, committed to working towards accreditation. Again, let me assure members that our states-owned entities are leading by example in this area. There is therefore no need for me to urge and assist them to seek the accreditation, since it's already either happened or will happen this year. Naturally, I will be monitoring the progress of the remaining 4 entities towards accreditation during the year. So whilst I will be supporting this proposition, well-intentioned though it may be, it will not necessarily be making the modest improvement the Senator wishes, since Jersey-based employees of these entities are already paid above the living wage. Thank you, sir.
Right. Does any other member wish to speak on the proposition? Deputy Sutton.
Yes, sir, and it's a straightforward case of Rule 3 in my society, which is always put a date on a proposition. And the missing thing here, since 2018, has been the date by which we're asking people to move, change their behaviours. And it hasn't worked so far. So it's absolutely essential that we do accept this proposition because it has got a date on it. It's not an unreasonable date, given that we've already had 4 years in which to attempt to convert all of our positions to living wage. Another year, basically, is what we're asking, and we want all of our state-owned subsidiaries to be paying the living wage. It's not unreasonable, but requires that date to hang on in there in order that hopefully we should succeed in meeting that particular date.
Conor Tarbison-Brillard.
Thank you, sir. With all these things, I'm always interested in understanding the consequences. And if wages go up, there is a consequent raise in charges. And I just wonder if the Senator could let us have his thoughts on whether there would be an anticipated raise in charges by State Department as a result of adopting this proposition. Thank you, sir.
Does any other member wish to speak on the proposition? No other member wishes to speak? Then I close the debate and call upon the Senator to respond.
Thank you, sir. I thank those that have spoken and pleased that it seems to be a relatively short debate. A couple of comments in response to some of what has been said. The Treasury Minister has pointed out that the Jersey-based employees of the government-owned companies are already paid the living wage. That is true, and it was true at the point that the Minister answered the original question. My understanding is that it wasn't the case until relatively shortly before I asked that question, because it provoked some of these companies to check their payrolls just to make sure, and some of them had to make minor adjustments, which means just by asking the question, some people out there got pay rises to the living wage. So I'm quite pleased with that, to be perfectly honest. And it is the case that now they're all paid the living wage. But remember, accreditation as a living wage employer is not just about the here and now, and it's not just about the employees who you directly employ. If you become accredited, you are expected to maintain that status as a living wage employer as long as you maintain that accreditation. So that means that when the living wage rate is uprated, then those workers who are paid below what it's uprated to must have their pay uprated as well. And that's a good thing because it provides those workers with certainty that they will get pay increases as the living wage increases. It's good that they know they don't have to negotiate and fight for that. And that's good for the businesses to know that they won't have to negotiate on that point as well. It simply becomes automatic. And the other thing that it requires is for when those businesses contract with other businesses, that those who work for them on that basis have to be paid living wage rates whilst they're working for them as well. And that can have a positive impact on things like cleaners, for example, when they're working on site to make sure that they're going to pay that. So the purpose of this proposition is not to ensure that upon its adoption, that large swathes of people working for the government-owned companies immediately get pay rises, because of course that won't happen. It's about the living wage permeating throughout the rest of society and through the economy as well, so that it becomes a point that when you're having to contract with another business, that business knows that it's not going to get the job if they don't pay their workers living wage rates as well. So that's a good thing, and it assists those people in those low pay jobs as well. Councillor St-Brelard asked about the consequences in raising charges. And in the short term, there's no need for that at all, because that accreditation process, I think, is straightforward. The Minister said the accreditation process is not simple. I think the wording should change there. It's not necessarily the process that isn't simple, it's the implications upon your accreditation that can be less simple if it turns out you do have lots of contracts out there with employers that don't pay the living wage. And I know that Caritas are perfectly happy to sit with those businesses and go through that. So it's more a long-term benefit that would be obtained through there, and we would get plenty of notice, and how the government plans would have to account for that in terms of the financial returns that those companies provide back to the states. So in the short term, certainly that has absolutely no implications for raising charges. There's little more to be said. It sounds like that this is going to happen, and by the end of the year, that hopefully these companies will have become accredited living wage employers. Let's tick that off the list, and next on the list is to get the minimum wage up to living wage rates. We've tried on several occasions to push in that direction, have not got to where we should have been by this point, and ultimately this proposition is to try and catch something positive before the electoral term is up. But for the government companies and the people who I've spoken to in those companies who are worried about their competitiveness, I would like to offer a word of assurance to them that we will do everything we can to make it politically impossible for the next government to not seek to apply these standards to those who they're competing against as well. So there is a level playing field, and they won't have to worry about that as much. So I ask for the appel.
Well, I'd like members to return to their seats and ask the greffier to open the voting. Members have had the opportunity of casting their votes. Then I ask the greffier to close the voting. The proposition has been adopted. 43 votes for, no votes contra, no abstentions. The next item of public business is the draft I've got this, which isn't on my script. Is this what you're expecting to do next?
Yes.
Okay, it isn't on the script. Okay. Right. Is the draft public elections, donations to political parties, threshold amount, Jersey regulations lodged by the Privileges and Procedures Committee, and I ask the greffier to read the citation.
Draft public elections, donations to political parties, threshold amount, Jersey regulations 2000. The states make these regulations under Article 13A of the Public Elections Expenditure and Donations Jersey Law 2014.
Chair.
Thank you, sir. Members may recall that Articles 13A to 13D were inserted into the Public Elections Expenditure and Donations Law 2014, which established a regime for political parties to report donations. The provision requires the treasurer of a political party to deliver a written declaration to the Jersey Electoral Authority of a reportable donation within 4 weeks of receiving it. A donation is reportable if its amount or value exceeds a certain threshold amount, or if the total of amount or value of that donation and any others made by the same donor within the preceding 3 months exceed the threshold amount. When this new regime was inserted into the law, it was stipulated that the threshold amount would be specified in regulations. Sir, before lodging these regulations, the committee looked at threshold levels elsewhere. In the UK, for example, the Political Parties, Elections and Referendums Act of 2000, which governs donations to MPs and political parties, any contribution of more than £500 must be declared. A donation under £500 is not regarded as reportable, and political parties are not required to keep records of the names and addresses of people making such payments. It is an offence to attempt to evade the controls on donations, for instance by donating more than £500 via multiple small payments. In local elections in Wales and Scotland, the limit is far lower, with all donations of £50 or more declarable. The committee passed on its research to the Jersey Electoral Authority and asked it to consider this matter. The JEA determined that the threshold should be set at £500 for political parties in Jersey. A donation under £500 will not be regarded as reportable, and political parties will not be required to keep records of the names and addresses of people making such payments. However, it will be an offence to attempt to evade the controls on donations, for instance, by donating more than £500 via multiple small payments. Thank you, sir. I move the proposition.
Very well. Are the principles seconded? Does any member wish to speak on the principles? Conatapa St Brelard.
Thank you, sir. I would ask the rapporteur just to clarify for me whether multiple donations of, say, £500 can be accommodated. It seems to me that if that is the case, parties could accumulate significant amounts in terms of donations. I can understand if it's for one, but it could be 10 or more, however many, and that's not clear to me. Thank you.
Does any other member wish to speak on the principles? Deputy Young.
So I noticed in the report that the limit for individual members who are standing in the election for declaring donations is £120 to £145, whereas political parties it's £500, and of course there is the opportunity for multiple donations. I wonder if the rapporteur or the chair of PPC could just explain their thinking of the differential there, please. Thank you.
Indeed. Senator Pallett.
Thank you, sir. I just wanted to say that as the leader of Progress Party, we're fully supportive of these changes. We have our own rules and constitution, which makes it quite clear that we have to follow tight guidelines in regards to any donations that we receive. And I'm extremely comfortable that as a party we will meet all the responsibilities of this legislation. The good thing of being a party is that we've got a number of members who will hold us to account if we don't abide by the strong rules that we put in place under our constitution. So anybody that's listening that are fearful of parties and what they may or may not get up to in terms of raising money and raising donations, please don't be fearful. I'm sure all the parties that will be involved in this election will play by the rules, play by the guidelines, and be respectful of each other. So I fully support this new legislation, and I thank PPC for bringing it as well. Thank you.
Very much, Senator. Does any other member wish to speak on the principles? Deputy Ward.
Thank you, sir. I'm speaking because I want to, whatever, who may be on the opposite sides of a coin later on, but I would like to agree with Senator Pallett and say that's exactly the attitude. And I think that's a very good point made about one thing about a party as you form and as you develop and your membership grows, you have an added level of criticism as to what you're doing, to be quite frank, and it can be a double-edged sword in many ways, but also it also can keep you in check if you get your organisation right, and I think that is the case. And I would also say that I urge all newly formed parties and indeed independents to really do look closely at the rules and abide by them so that the election is fair and well conducted. And I think recognising party politics in this way and donations is a step forward that we desperately need. And it also puts some checks and balances in the way, because without that, there would be real problems, I think, into the future. And at a time where we talk about democracy around the world and the importance of it, and we see attacks on democracy, it's really important that we all play our part in maintaining our own, and this is one of the important things to do that. Thank you, sir.
Much indeed. Does anyone else wish to speak on the principles? Deputy St Peter.
So we, within the Jersey Alliance, we weren't prepared for this to speak, but I think I'll take it upon myself as the former chairman just to say we totally support this and concur with everything that's been said by our fellow colleagues in the chamber as we move forward, potentially with party politics. Thank you, sir.
Does any other member wish to speak on the principles? Yes. Is there any other party that wishes to speak on the principles? Yes. If no other member wishes to speak on the principles, then I close the debate and call upon the chair to respond.
Thank you, sir, and thank you to everybody who contributed. So with regards to the Constable of St Ballard's query, it is an offence to evade the controls on donations, so by donating more than 500 via multiple small payments, and that if it's done over the course of, if the total amount or value of a donation made by the same donor within 3 months also exceeds that 500 threshold, it also has to be declared. So I hope that's made that clear. With regards to the point raised about the independence threshold, so it was raised from 120 to 145 in line with RPI. We tracked back RPI to the last time it was raised and raised it by that percentage. But this was considered too low for party donations, which is why the £500 was chosen. We did consider adopting the level used elsewhere, which was 15 times the personal rate, but this would have resulted in parties having to only needed to declare a donation of £2,000 roughly or more, which we thought was quite a high amount. And given the limits in the UK for national parties, that's why we ended up suggesting capping the donation at £500, which is roughly 3 times the independent limit. Obviously, going forwards, the Jersey Election Authority will be the ones that will be overseeing this and making recommendations after this election, and I'm sure they will probably be gauging feedback from members as well. So if members do have any feedback on this, either before or after the elections, then they are free to get in contact with the JEA, who will then obviously make recommendations to the new PPC and take those forwards. So, sir, I maintain the proposition. Thank you.
Very well. I invite members to return to their seats, and I ask the greffier to open the voting. Members will have the opportunity of casting their votes. And I ask the greffier to close the voting. The principles have been adopted, 42 votes pour, 1 vote contre, no abstentions.
The Constable of St Ballard.
Does the Corporate Services Scrutiny Panel wish to call the matter in?
No, sir. Thank you.
Very much indeed. How do you wish to deal with the matter in second reading, Chair? If you could stand up, please.
En bloc, please, sir.
Yes. Is it seconded for second reading?
Yes, sir.
Thank you very much. Does any member wish to speak in second reading? If no member wishes to speak in second reading, Then I close the debate and ask the greffier to open the voting. Members have had the opportunity of casting their votes. Then I ask the greffier to close the voting. The articles have been adopted in second reading. 40 votes pour, 1 vote contre, no abstentions. You propose the matter in a third reading, Chair.
Yes, please, sir.
Is it seconded for third reading?
Yes, sir.
Does any member wish to speak in third reading? If no member wishes to speak in third reading, then I close the debate and I ask the greffier to open the voting. If members have had the opportunity of casting their vote, then I ask the greffier to close the voting. The regulations have been adopted in third reading, 41 votes pour, 1 vote contre, no abstentions. Very well. Before moving on to the final item listed in the order paper, could I just ask the External Relations Minister, Minister, I have approved earlier on the lodging of regulations relating to shipping in connection with sanctions. Is this something you're going to ask the Assembly to take on at this meeting as well?
Indeed it is, sir, if I may. I'm grateful to the GREF who have now circulated it to members in the normal way, so I'll need to seek the
You will. I won't ask you to do it now, because Deputy Pershard is prior in time.
Yeah.
But I just wanted to know what was coming up for the guidance of the Assembly.
Yes, indeed, sir, if I may, whether that be this afternoon or tomorrow.
Well, we'll move on with the debate on Deputy Doublet's proposition now, and then we will see where that leaves us in terms of timing. Very well. The final item listed.
Sorry,
yes.
sir. I'm just thinking about the timing of the regulation. Of course, right for Deputy Doublet to go now. It would be ideal if I suppose we should see where we get to at the end of the day, if it could be agreed today, because then it comes into effect tomorrow, giving us little time gap between the sanction and the order which I signed yesterday, which brought into effect the overarching sanctions. This is a regulatory change that requires a change to instruct the registrar in effect. So it would be better if it could be taken after Deputy Doublet's proposal. If we get that done this afternoon.
If Deputy Pershard doesn't wish to object to that, then I see no reason why we can't take it.
Sir, I think I would. I was waiting for the appropriate time to then propose that my proposition was debated, but my understanding was I was going to wait until after Deputy Doublet's proposition to seek the approval of the Assembly. But if we are going to discuss it now, I would prefer to do it in order of the arrival of the late propositions.
No, well, in which case I think, Deputy, the right thing to do is we'll deal with Deputy Doublet's proposition. We'll see where we're placed at the end of that debate. If there's time left to deal with the other matters, then we will. I think we must deal with that proposition first. But it's likely at the end of it, there'll at least be the opportunity to determine whether the proposition is taken today or not.
Thank you, sir.
Well, the last item listed then is legal parent status and parental responsibility for same-sex parents, P26, lodged by Deputy Doublé. The main respondent will be the Minister for Children and Education. I ask the greffier to read the citation.
The State has to decide whether of opinion to request the Minister for Children and Education to prioritise work on legislation to remove the discrimination in our law with regards to legal parent status and parental responsibility for same-sex parents, that a draft law on the matter can be lodged in time for debate before the election.
Deputy Doublé.
Thank you, sir. So our current laws actively discriminate against same-sex couples. I think, given some of the discussions I've had with members in recent days, I think many were surprised to discover that same-sex couples do not have the same rights in respect of legal parent status and parental responsibility for their children as do heterosexual or mixed-sex couples. The report accompanying my proposition quotes some real-life examples from couples here in Jersey, and I know that we have also had many of these couples and their families contacting us via email to tell their stories and to urge us to take action on this. Imagine watching your wife going through a difficult birth to bring your child into the world and knowing that if anything happened to the baby, you would not have the right to make decisions about your own child's medical care. Imagine working overtime and saving money for years to fund IVF treatment, and then when registering the birth of your child with your wife, you are told that your name will not be on the birth certificate. I could go on, sir, and I think the level of surprise that members have shown on this particular detail, that even when couples go through the processes that our law requires to obtain parental responsibility, there is still no avenue within our laws that allow some couples to have both names on the birth certificate. There are parents here in Jersey who have children in primary school and older who have joint parental responsibility, but one of the parents is still not allowed to be on their own child's birth certificate. When a same-sex couple decides to have a child, it is never a decision taken lightly. Often, processes such as IVF or surrogacy are required, and couples frequently invest many thousands of pounds, tens of thousands of pounds, and years of their lives trying to conceive a much-wanted child. And then, sir, once the child is born, to be told that more processes are required, court fees, again, sometimes into the thousands. And as the chair of Liberate pointed out in an email to members, it can still be several months before parental responsibility is achieved through the court. So the child and family are in limbo for that time. Families report feeling humiliated, disempowered, and exhausted by all of this. So political commitments have been made to rectify this awful situation. As far back as 2016, the previous government committed to changing the law. The work was not completed. The current government committed to changing the law and are now telling us the work will not be completed in time. So that's 2 entire political terms that will have come and gone if we do not address this today. We have absolutely no guarantee that the next government will be minded to get this work done quickly or at all. It's not just the affected families calling for this change, sir. In 2019, the Jersey Law Commission commissioned an independent report authored by Marisa Allman, a barrister for England and Wales. And this report clearly identified the anomalies in our legislation and how to remove the discrimination in the current law. The work, the background work, was all there. And the summary of this report stated that Jersey now has discrimination legislation, but the law itself discriminates against many parents. So I'm grateful that the previous minister, Deputy Masson, kept this work as a priority, and I could see him doing this. The current minister also, he has maintained this because he did sign the law drafting instructions that he was presented with, I think, fairly soon after he took up his role. And so until very recently, a matter of a few weeks, I and the group of parents involved were receiving the message that the work was still progressing at pace and there was no question of it being delayed beyond the current political term. But however, here we are, weeks from the final sitting of the term, and we're suddenly told that the work is not ready. This is a shock, sir, and not what families were expecting. I do thank the Minister for his comments paper. It was presented in good time, and I do appreciate that. I wish to respond to a criticism within the document and to draw the Minister's attention to the fact that although the scrutiny panel have, of course, worked hard on this and scrutinised it as they would any other legislation within their remit, this issue is something I have been campaigning on for some time, prior to my membership of the current panel under the excellent leadership of Deputy Ward. It is also an issue that has seen campaigning from members of the public. Representatives of a group of same-sex parents who were receiving updates from officers informed me they were suddenly not getting responses to their emails. After further efforts on their part to make contact, they were given an update which I then had sight of, and it was this update and the disbelief and dismay of the affected families that prompted me to respond as quickly as I could with a proposition. I'm grateful for the support of Senator Farnham, who, acting as Deputy Chief Minister in response to a question about this legislation on the 8th of February this year, confirmed that it is important, this issue is important, and it must remain a priority for this government. And to be clear, sir, I want to mention the policy officer who was tasked with this work, because I believe he has been diligent and focused. And again, I'm grateful to him for his efforts. He was previously excellent at keeping me updated. He's taken time to explain and discuss the law with me and was open to consulting with the same-sex parents and their families. I don't believe any fault lies with him at all. It is my view that this is a resourcing issue and that had sufficient political importance been placed on this work, it could surely have been completed in the nearly 6 years since Senator Gorst made his commitment as the Chief Minister at the time. I find it hard to believe that a law which a few weeks ago was on track for completion before the end of this political term now suddenly cannot possibly be completed in the remaining time. The Minister, in his comments, cites issues that have supposedly arisen recently, including problems related to the UK Human Fertilisation and Embryology Act. However, these issues, as I understand it, are not new and were being discussed years ago, as I and others recall. The comments go on, sir, to describe review processes that will take many weeks. And whilst I do respect these processes, I don't know about other members, sir, but I am tired of hearing this argument that these processes are getting in the way of progress on things that this Assembly deems to be important. The States of Jersey, it's like this big machine, isn't it, that we've created. And with all its gears and cogs, we created it to put into effect the will of this Assembly, not the other way around. And we have seen how quickly legislation can be prepared and can pass through all of the necessary checks with COVID legislation. And indeed, legislation that I think was lodged a few days before this sitting, and indeed being lodged today, that we will be debated today. It can be done, sir. It can be done if this Assembly believes it to be a priority and this Assembly instructs the government for it to be done. So I believe that this legislation is not ready because it has been deprioritised. Again, the Minister's comments describe how it had to compete with other children's law and family law work. And so I find this a horrible concept. Why are we not putting all legislation relating to children as our utmost priority, as we have committed to do in putting children first? Why has this particular piece of work been pushed to the bottom of the pile? I cannot help wondering, sir, if it is because it affects a group of people who are so used to being marginalised and labelled as other, who are so used to having their basic human rights denied, that we assume they will simply pipe down and wait. The lack of equality between same-sex and mixed-sex couples is shameful. So members will see from the influx of support over the last couple of days that it is very clear what the public want us to do, and we are here to represent the public. One email we've received, and I want to thank everybody who has got in touch. One email we received reads as follows. As a great-grandfather, I find it highly embarrassing, to say the least, in 2022, to explain to friends and acquaintances that my granddaughter-in-law is not permitted to have her name on her son's birth certificate. Sir, we have a few weeks left before the last sitting of the Assembly. We do have the capability, with your approval, sir, to debate urgent legislation in the next 3 months that we have left. I am calling on this Assembly to instruct the Minister that this issue is a priority and that the draft law should be lodged for debate before the election. I did not just lodge this on a whim, sir. Members know I would only ever bring something to the Assembly that I think is evidenced and reasonable, and which I have sought advice on myself and considered thoroughly. We know what can be done. We've seen how quickly we can work during COVID. And I do understand and I do appreciate that this will mean hard work for all involved. And I think it goes without saying, again, this was something mentioned in the Minister's comments, the scrutiny process. It goes without saying that we in scrutiny would be prepared to put in whatever time is needed to scrutinise this. And I make that commitment myself. But I believe, sir, that the children of these families deserve that hard work, and they deserve the support of this Assembly today. So please show that support by voting in favour. Thank you.
Indeed. Is the proposition seconded? Deputy Wickenden.
Thank you, sir. Sir, I applaud Deputy Doublet's commitment to this legislation, which, as she rightly says, will address a long-standing matter. I, like the Deputy, am equally determined that our law provides same-sex parents the same rights as opposed-sex parents. I too am unhappy that this legislation was not prioritised by the previous Children's Minister at the beginning of this term, which has caused these delays in bringing forward the legislation and as highlighted in Deputy Doublet's report. So I can assure the Assembly that under my and Deputy Mattell's time, this legislation has been prioritised and significant progress has been made. We cannot ignore that this legislation has had to compete with other children's laws and family laws and work, and also the impact of the pandemic. Sir, I and Deputy Mattell were briefed on the draft law early last year. We gave our full support to it and instructed officers to prepare the ministerial decision for law instructions. Officers then briefed the Minister for Home Affairs, and just 7 days after, I signed the ministerial decision. As the Assembly can see, this legislation was a priority for myself and Deputy Mattell then, and it remains a priority now. Sir, we already have a consultant law drafting officer in place. The policy intent that underlies the legislation has been determined as described in Appendix 1 of my comments paper, and an initial working draft has been produced. So the Deputy states in her proposition that she wonders whether the legislation has not been prioritised because it affects a group of people who have historically been marginalised and therefore do not seek to campaign loudly when their rights are denied, as she has just mentioned in her opening speech, sir. She then goes on to say that she believes the legislation is not ready because it's been deprioritised. So I hope members will agree that the evidence of progress that I've provided clearly in my comments paper demonstrates the Deputy's belief is simply incorrect. The legislation is a priority and it has not been deprioritised by me. So the Deputy says she struggles to see why the deadline the Deputy has set out should be a challenge. And the Deputy says this despite my letters of the Children, Education and Home Affairs Scrutiny Panel setting out the challenges to this law, which they received 4 days before the Deputy lodged this proposition P26. My letter clearly advised the panel and Deputy Dubé as Vice Chair of the panel that in developing the working draft, officers have identified several highly complex and previously unknown issues, which they are working to resolve. The issues previously advised by the letter to the panel include the complexity that arises from the fact that Jersey does not have in place an equivalent to the UK's Human Fertilisation and Embryology Act 2008. In bringing forward legislation in Jersey to provide for parental responsibility for same-sex parents, we are required to create a new concept in law. For example, the concept that a child may have 2 parents of the same sex who may acquire legal parental status and parental responsibility without having to adopt that child, as well as new processes, for example, a new parental order that allows intended parents, including 2 fathers, to become a child's legal parents and hold parental responsibility. When the UK legislated for parental responsibility for same-sex parents, they hung those concepts and processes of provisions that already existing in their 2008 Act. We are unable to do that, sir. Also, challenges that arise when determining the domicile of origin for children of same-sex parents, as the concept of domicile of origin arises from customary law, which does not recognise same-sex parents. This is important because domicile of origin is the concept the courts use to determine which legal system applies to an individual who has connections with more than one jurisdiction and is relevant in matters of personal law, tax law and inheritance law. Failure to resolve matters relating to domicile of origin creates significant uncertainty for children and their parents. So officers are working to resolve these issues, but this is not the end of the process, as a series of pre-lodging reviews and checks need to be undertaken. These checks are common to all law drafting processes and include a review by key professional stakeholders in relation to parental responsibility for same-sex parents. This entails a review of the court's order-making powers set out in draft legislation by the Judicial Breviary and the Family Court, a review of the law from a safeguarding and operational perspective by the Children's Service and Jersey Court Family Advisory Service. This is common to any legislation that relates to parental responsibility and associated matters. Consideration of children's rights by the Children's Commissioner. A review of provisions relating to the sealing of birth certificates, the issuing of parental order certificate and recording of prescribed particulars which provide foundations for a child's identity by the Superintendent Registrar. There is a legal review, sir. The law officer's advice would be required on any amendments arising for the review by key professional stakeholders and would then need to undertake a legal review of the financial draft legislation. Advice would also be required on the compatibility of the legislation with the European Convention on Human Rights. There will be law drafting checks, sir. The Legislative Drafting Office editorial review team must review the draft law for errors and anomalies. The review process I just described will take many weeks, and it is a process that would be unwise to shortcut through. A number of those stakeholders who need to engage in these review processes have expressed to my officers significant reservations about any proposal to push for pre-election lodging. They advise that the time frame is unrealistic and presents a very real possibility of bringing forward flawed legislation that presents risks to the very children and their parents the law is there to protect. Furthermore, neither this Assembly nor the scrutiny panel would have adequate time to review and scrutinise the legislation. Legislation, I'm informed, will most likely be going for lodging in October this year. Sir, It is entirely right that we provide for same-sex parents and put a stop to the feeling of stress and humiliation reported by them. But we also need to get the legislation right, as there are few statutory provisions more powerful in a child's life than ones that determine who their parents are. Sir, I'm in the hands of the Assembly and yourself. I can ask for other works to be stopped by the law drafters to work on this law, and I can bring forward a form of the legislation to be created by this Assembly. However, sir, the Assembly needs to be aware that what I bring forward will require a seriously reduced lodging period, as I will not be able to lodge this by March the 10th deadline, and it may not be correct and complete. The law would not have gone through the proper consultation with all the bodies I mentioned earlier and may contain errors. Sir, I for one am not happy with bringing forward rushed legislation to the Assembly and will be voting to abstain the Deputy's proposition, not because I do not support the LGBTQ community, but because I do support them. And I want the law to be correct with no unintended consequences that would further cause harm or distress to them and their children. Sir, I have laid out the bare facts for the Assembly to consider, and I am in their hands. I will endeavour to do the very best of my ability to bring forward this legislation before the election, if that is the will of this Assembly, and I will endeavour to get as much consultation as possible between now and the 29th of April, which is the last time this could be debated for election, sir. Sir, it will be up to the Assembly to decide what the outcome of this proposition is. But I lay out the challenges and the risks. Thank you, sir.
Very much. Conor St John.
Thank you, sir. So yesterday, Senator Gorse described me as being radical. A strange description for someone who was doing their very best to actually preserve our history and tradition. If the Senator thinks I'm radical due to wanting equality and inclusive language, I think that probably says more about him than me. It's probably just as well, sir, that I didn't raise my concerns yesterday about the lack of ability to hold a same-sex marriage in a parish church, a public building. I would prefer to be called a moderniser, someone who constantly looks at ways of improving how we do things, how do we keep up with best practice, and how do we remain relevant. The proposer spoke about priorities and putting children first, and I agree with her sentiment. So here we are, sir, my 12th month in this Assembly, and I've still not been asked to sign the pledge of putting children first. Hopefully, my voting record and comments in this Assembly will demonstrate my commitment not only to children, but to our community. If I'd been asked for my view, I would have happily signed the pledge, but I feel it would have been even better if it was actually putting families first. Oh, there I go again, sir, looking to change and improve things. Like all members, I've received a high level of correspondence on this subject, and I apologise to those I haven't been able to answer so far. The first question I asked myself was, how has it got to this? The report attached to the proposition tells us it's been going on for years, something Liberate confirmed in their communications. Sir, a child deserves the best start in life, and that includes having both their legal parents on their birth certificate. The Minister spoke about domicile issues, and I'd say to him that it is totally wrong when local families have had to give serious consideration to going to the UK for the birth of their child to enable both parents to be on the birth certificate. They should be at home, surrounded by family and friends, just as any other couple would enjoy. We heard about a long list of things to do, about lots of consultation. Well, sir, we've had years and years and years to do those things and to carry out that consultation. I cannot believe that none of these have started. We all have to prioritise. For me, this is both urgent and important, so it should receive the resource it requires. Sir, members today have an opportunity to put children first to put families first by supporting the proposition, and I urge members not to miss the opportunity. Thank you.
Very much, Conectar. Does any other member wish to speak on the proposition? Deputy Ward.
Thank you, sir. I feel I should speak. There's a couple of things I'd like to say on this. We keep mentioning scrutiny panels. I'd like to say, so the scrutiny panels are not there to do the minister's job. Scrutiny panels are there to scrutinise the work put forward by the minister. And I do feel, and I don't know about other scrutiny panels, at times that's been blurred, and we've had to put so much work in to try and correct or try and push something forward. That's not what the role is about. It's about what the word says, scrutinising what already exists. So leadership is not about looking back and saying, well, it didn't get done because somebody before me didn't do what I thought they should do. It's about doing things now and taking the lead. So I'm a parent. I'm a very traditional parent. My wife, we had our children, we had no problem registering their birth, etc., etc. But the one thing I know, sir, that me being a parent is completely not about simply because I'm male, my wife is female, and we fit some traditional model. It's because my children, however they would come about, whether they are children that my wife gave birth to, children we may have adopted, children someone else gave birth to, but we took on as a parent, are our children. And that is true for everybody who takes on the role of a parent, an incredibly special role in our society. And what we have to do as an assembly, if we have any ounce of decency to us, is to recognise that across our society. There are so many good parents out there who don't fit the model. That I don't even know where the model came from, track back through history. Society has moved on. We have to move on. And I welcome the modernisers. I hope I'm called a radical. I hope I'm called a moderniser. It's a good thing. It's a positive thing. And this is an example for this assembly to do that. I recognise it's a challenge for the minister, but I'm sure that being a minister is a challenge. Therefore, take on the challenge. I compliment Deputy Doublé in her tenacity with this subject and keeping going and not being put off. It's not that again, I'm not going to justify what the scrutiny panel has done because we've done so much. This is about the work that individuals do as well. And I will say this as well. If you look back through this assembly, how much has been brought forward by backbenchers or non-executive members because it simply hasn't been brought from anywhere else. And so, sir, I urge members to support this. Let's go for this. Let's get the minister to do it. And if it requires a reduced lodging period, I'm sure this assembly can do that. So we have an election in May. Nobody knows whether they're going to be here and what the next iteration of this assembly is going to be. So we have opportunities now to do important things. This is an important thing. This will change people's lives. This will make our society better. Surely that's on our job description. So I urge members to support this proposition. Thank you, sir.
Does any other member wish to speak on the proposition? Deputy Martin.
Yes, thank you, sir. And
I'm sorry, Deputy. I should have called on Deputy Young first, who I'd noted prior in time on the link. So I'll call Deputy Young first and then you afterwards.
Okay.
Thank you, sir. I like most other, in fact, all other members. I've been shocked to realise the gaps in our current legislation and the dated nature of it that disadvantages very severely opposite-sex couples and failures to deal with the reality of surrogacy and all of the things now which modern family circumstances expect to be part of our legislation. But I suppose, in all honesty, having been associated with the States for many years as a civil servant and the last few years as a minister, I shouldn't be surprised. And the reality is that our legislation generally, right across the piece, in social and environmental matters, particularly civil matters, I think woefully needs reform. But of course, the reality is, and I'm sure that if Deputy Doublé maintains her passion and conviction and commitment, she will be a minister at some point. And then I think she will then experience the practicalities and realities that, as ministers, apologies, sir, none, my phone, the guy with the money, it's ringing. None of us as ministers are lawyers. We have to use the resources we can win, resources that are competitively sought after to achieve reform. And looking at the list, I really feel for our education minister, who absolutely, I know, shares the passion and conviction of the deputy to want to see this done. And I feel the frustration when you're faced with the reality that, oh dear, people persist. So I do apologise, sir.
It's all right, Deputy Young. We actually can't hear what's going on back in your environment, so there's no need to apologise. As so far, we can only hear you.
Oh, thank you, sir. It's just that my telephone has been going, which is something which is remiss.
Well, I haven't given you a caution, so I won't take that as a confession, and therefore I won't fine you.
Thank you very much, sir. So I really can feel for Deputy Wickenden's frustration. But the reality is we have to work within a system of rules whereby we have to win that resource, and we can go forward with legislation that we don't think has been or advised has been fully checked out and may have snags in it. In fact, this is possibly one case where if it's better to have some legislation, except in fact it may not be perfect or will need to be changed, than not have it. So I accept the validity of that argument. But my wider point is this. I certainly could produce, as Minister for Environment, an equally long list of major changes which, after working for 4 years, I've had to accept can't be done in the timescale. We've run out of time. And those affect things to do with nuisance, noise, things that really upset people in their lives. And, cause massive mental health stress. Those are things. The planning and building law desperately needs improvement in another area, but I have to accept as a minister, I could not succeed in bringing this through in the time. And I'm sure when the deputy becomes a minister, she will feel that. My solution is this. We have in the last 4 years, I can't recall a state's sitting when we haven't had a flood of financial services legislation to deal with. Now that's good. I want to see in future the new Council of Ministers achieve a better balance of resources, because we can't expect our lawyers team to do the impossible. And we need the teams of officers to be able to help us with the instructions which are in civil and social legislation and environment very complex. So we need to give that priority in the future. So I think that would be my lesson today. The one thing I don't agree with in Deputy Doubilet is the fact I think Deputy Doubilet understandably made the case of opposite sex partners, but there are others, but that's equally, looking at the list in Appendix 1 of the comments that the Minister presented, there's points A to G there. All of these seem to be serious gaps. So absolutely priority. Now, I think on balance, I will go along with this, but I make those points that I think 18 days to produce legislation which we're told is complex, may have holes and snags in it, but if the states believe that's the right thing to do, challenge to produce that if at all possible, accepting the fact it may not be correct. That's that's one way to go. But I think in this situation, there does need to be a greater balance of equality of resources available to ministers in the future, so we can catch up, because there are many other areas of this. But I think absolutely none of that detracts in any way whatsoever from the passion of the deputy, the determination and efforts she brings in her social legislation to modernise our society. And none of that at all undervalues in any way the commitment of our children and education minister, who I've seen at first hand, his determination and dedication. So that's the situation we're in. It's not an ideal situation. We have to make our choices. I think I will go along it, but I've made those points, those reservations at all. And it might be, we've got 18 days. Obviously, the bailiff, sir, you, sir, will need, if this comes forward, to be able to allow that legislation to be debated in 18 days' time under Standing Order 19A, because those are the rules we set. And maybe, sir, if some of my priorities on environmental matters that I've not been able to bring through, that could be ready, maybe I might have the opportunity, sir, of doing the same thing. Because I think this is a broader issue than just personalising it about a minister dragging. It's absolutely not ministers dragging their feet. Thank you, sir.
Thank you very much. Deputy Martin.
Thank you, sir. And I thought I would not stand here one day and hear a minister say that we should pass a law that probably is not going to work. It probably can't go through you, sir. But I'll just go with it anyway. And I'm sorry, Deputy Young, but that's what you just said. I listened to the Constable of St John, and he's talking about parents, and we're talking about same-sex couples and birth certificates and rights. And for all the people that have emailed me, let me say to you, I've emailed some of you back, nobody is disagreeing with this. It was agreed, it is agreed in principle, and it will be done. Now, yes, somebody took the eye off the ball, but I can assure you, sir, since Deputy Masson was Children's Minister and then Deputy Wickenden, they have now put the eye back on the ball and put the right people in charge. Then we had this turn up a few days ago. Can I have early lodging? Can we have a discussion? And I ask all the right questions. And it seems to me you've got the Assembly is absolutely doubting that the Children's Minister is doing his best with somebody who's writing this law. It's not as simple. When you have same-sex, there's going to be a third person involved. It's a surrogate. It's somebody who is giving birth, but somebody who's not the parent, somebody who has done this. And there's all these things that have to be considered. Deputy Doublet's right. Well, make it an election issue. It can't be done. I believe a good law cannot be passed, and I'm not supporting Deputy Doublet on this because I've already stated a few years back, I've done my bit family friendly. Nobody bought it then. I had to work around the rules on the family friendly and who was the second parent, etc., etc. Wasn't so much, it was being done, but nothing was pushed. Worked around that. Today, to me, it's, the Education Children's Minister is basically telling us he is doing everything he can. And what really, and I'm glad I wasn't called straight away, sir, in Deputy Doublet's speech, he basically said, we are sidelining these people because we don't care. They don't have a voice. I absolutely take offence to that, sir. I defend the rights of everybody, and I've supported same-sex marriage, everything all the way through, and I support this. It can't be done. So we have Deputy Doublet with a passion, who, as Deputy Young has just said, in the new Assembly, if she's re-elected, will be Children's Minister. And you make this an election issue. If it's not done by the time, it can't be done. It's days. We're going to have a whole week or two. We have 100 amendments to the Island Plan. And we've got to squeeze this in. We've got to make some ruling from you. When I read that ruling, sir, to me, and it is an awful place we're in, that standing order should have only been used if we had another COVID-20 or a war going on over the Europe. We've got one of those going on, sir. But that's not to distract that this is important to the people that we're trying to help. But it's got to be right. I Deputy Wickenden emailed us all last night, and he was disappointed this was allowed. I voted for the debate so I could express everything that I've heard. We've pushed, we said, can you do it? Can't be done. And if anybody thinks that we can start passing bad laws that don't reflect all these issues, it really, really, really is a bad day, sir, and I would not be happy to be a member of this assembly. Thank you.
Very much, Deputy. Does any other member wish to speak on this proposition?
Sir, I did ask for...
Yes, you did. Deputy, would you give way to Deputy Young for a point of clarification?
If I can help, sir, yeah.
Thank you, sir. Obviously, the Minister did comment on my statement about that this was an occasion where it's possible to bring forward the law. We should do it that wouldn't... I think the Deputy said wasn't fit for purpose. So would the Deputy accept that I was perhaps paraphrasing and should have referred to the review processes that the Minister of Children had set out in his report, not necessarily be able to do those final checks, review processes?
I'm sorry, Deputy. I don't think you could ask the Deputy to accept that she thinks you would have been paraphrasing. You can clarify what you've actually said, or ask the Deputy to clarify what she's said, but really you're making a further point seeking to qualify what you have said in your speech.
I have to accept that, sir. Probably I should have used more careful words. Thank you.
Thank you very much indeed. Deputy St Peter.
Thank you very much, sir. I find myself between a rock and a hard place. And I also, I'm afraid to say, I see no short-term winner at the end of this debate, which either way it goes. We are invited by our parishes, sought to be plural, to make tough decisions on behalf of those that we represent. And the criteria I look at is I want to make that decision to ensure that there is a positive outcome, whether that be a P or a C. And I don't mind whether that is for a large percentage of the community or a small percentage of the community. I want to see the positive outcome for those members of the community. Now, this is not about my support for the legislation of legal parent status for same-sex parents. I'm 100% behind that. And I suggest, if I'm reading this room, my fellow 48 members of the Assembly are in exactly the same mind. There may be exceptions, no doubt we'll hear from them, but very, very few I would suggest. So this is about process, nothing else. It's about process. The principles are a given and are accepted. What troubles me most is, should I vote contra to this proposition, I can see the, what words do we use on social media which are negative? I can see the attacks that I'll be perceived as homophobic and out of touch and, grey, pale and stale or whatever else it is. However, I can assure the Assembly this is so not true. Anybody who knows me, my family, my friends, my godchildren will know how many times in my personal circumstances I have come across this, albeit not in Jersey, but in the UK. And I was sharing with Deputy Doublé one experience of some friends of mine's children in the UK, who two girls who shared each other's embryos to incubate each other's children, to bring total harmony to their family together, which I'm sure everybody's heard about it. It's the first time I heard about it. I thought it was a wonderful solution to unite that family together in a totally balanced way. Voting a poor means risking, we've heard about this absolutely clearly, poor legislation. We've heard from the Children's Minister quite clearly, Education Minister, sorry, how clearly we risk bringing this poor legislation. Deputy Martin said the same things. It is incredibly complex. We've had the comments paper. We listened to 2 speeches from Deputy Wickenden. It is an incredibly complex area that cannot be rushed through to ensure that the results will be the positive outcome that everybody in this island deserves, whether we're talking about these group of families or everybody. What's worse is I can see it now. The legislation isn't lodged within 10 days or 18 days with an exception, and then we'll get a vote of no confidence or a vote of censure or something like that will come up because we haven't met with the wish of the Assembly. So the outcome, sir, I see absolutely nobody winning. Poor legislation or alternatively the wrath of the island. I don't know what the solution is because there's no positive outcome. Maybe, perhaps we can persuade Deputy Doublé to withdraw this in the full knowledge. I knew she was going to shake her head, and quite rightly so. But to withdraw this, because there is a very clear statement from everybody who has spoken so far how important this is for the islands, and that could be perceived as the proverbial kick up the what's his name, sir, if that's parliamentary.
No, it isn't. In fact, you'd like to withdraw it.
Sorry, sir, I withdraw that. I thought it was touch and go. So I don't know. I could cop out and just make it just abstain and just say because I don't see a positive outcome. I struggle with this. I really want to see it go through. I want to see it go through successfully as quickly as possible. I can't see it happening in the next 18 days with a positive outcome. So whilst I've contributed neither positive or a negative to this, I just feel the Assembly need to know we really have bitten on something that is not going to have a pleasant conclusion in the short term, sir. Long term, I hope so.
Deputy Masson.
Thank you, sir. As members have heard, when this was brought to my attention when I was Minister, it was something which I absolutely wanted to prioritise and progress. I think what was important during that, the briefings that we had with officers, that they knew that there were families in this position who needed this legislative framework in place in order to do so. And that's why I was, so keen to prioritise it and have the work progressed by officers. I think it's important for members to realise it's obviously not ministers who sit down and draft the legislation. It's, they're giving instructions to officers to work with the Law Draftsman's Department, to work with the law officers in order to come back with a package of legislation for their ministers to look at and then approve. That is the process. And I am concerned with this proposition that effectively we're setting up the current minister to fail. Because if you look at the comments, and I would ask Deputy Doublé to respond to that, if you look at the comments about all the other bits of legislation which are important, which are for families, which are for children, all the bits that are also being worked on, and it's just the issue, as has previously said, it's not about supporting this legislation or this legislative change or not. It is the time frame for which it should come into. And I just want to bring to members' attention today, I think members are scoffing at the kind of the checking process that is going through, saying, oh, well, it doesn't really matter, we can just put it in place. Well, wait a minute. We've just had to change and correct something in this very sitting because it was only found by the officers looking through the law that the Education and Children Minister has just brought today. Today we found an error at the very last minute and we had to lodge changes. And I can't stress how awful it would be to have a family in a situation where we rush legislation through and then there's an error on the birth certificate. What an absolute nightmare to put those individuals in because of the will of the Assembly to rush something. It's so important that this particular aspect is done delicately and sensitively and properly. And I stress that, and properly. If members are concerned that, we have children coming and, this needs to be put in place, can I just remind them that there is a period after the birth where registration of birth can still happen. And the Minister is saying that there's an anticipation that this can come in the autumn. So there is a window of opportunity for those families affected to still be covered by this when it comes. So I need to hear from Deputy Doublé to say why the checking processes aren't important. That's what I need to hear from Deputy Doublé. Not, there's a great will for this to happen, or, families are crying out for that. I understand all that. But we are legislators, and we are there to do things properly and ensure that the legislation is fit for purpose. That is our job to do. And I'm deeply concerned that this request will, and I'm sure it will probably be supported by the Assembly. because, you know, we've got an election around the corner and they don't want to be seen as homophobes. I'm sure that will be the effect. But I'm certain that what we also will be doing is setting up the Education and Children's Minister to fail. And that is not going to look, and it's setting false expectations for the public. And that's my problem. Because I don't think that's fair on anyone. And I don't think it's fair for those people who are waiting for this legislation either. So that's what I need to hear from Deputy Doublé as to why that's not the case. Because that needs to be explained. I don't think she's done it in a report. I don't think she's done it in her opening speech to explain why the checking processes, which the Minister has identified are required, aren't needed. Because I, as a member of the acronym community, am great to hear the support from members of the state saying all of this, but I also want the laws to be done properly and in place. And it was incredibly frustrating having to wait for the equal marriage legislation, which went on for years and years and years. But it's because all the consequential amendments to all the other bits of legislation had to be put in place. And what we've seen from the Minister in his comments is this isn't a case of lack of resourcing, as if there aren't enough officers dedicated to it. It's just that it physically takes time to put all the bits together, to have the expertise in place in order to look at this. You know, this isn't a case of the Minister sitting on the law or just waiting for it to be lodged. It still needs to be written. And that takes time. And simply, you know, encouraging the law drafters and officers to work faster doesn't mean that you're going to produce something or produce something of quality, which is the other concern. So I think all members of the state want to see the legislation in place, but it's about the time frame and the practicalities of putting that in place. And I don't feel that Deputy Doublé has made the case as to explain the demand as to why the checking process suddenly is not important. And I look for her closing speech in order to clarify that, because that's my issue here. And I desperately want to support this, as I'm sure all members do, but I don't want to set up the Education and Children's Minister to fail. And members need to be realistic and they need to be practical. Thank you, sir.
Much Deputy Sutton.
Thank you, sir. And I've heard, I suppose, two major speeches today. One from the proposer, Deputy Doublé, who put together a somewhat emotive speech, but nonetheless which stuck to the facts and was very comprehensive and clear. And I was far more impressed by her presentation than I was with the response of the Minister. The Minister seemed prepared to pile on pile after pile of excuses. What we heard was 6 years of excuses. What we heard from this Minister was at least 4 years of excuses. What we've heard from the Chief Minister and the ex-Chief Minister was a commitment to this legislation which never happened. It often happens like that. We request that a Minister does something, the Minister goes away and does absolutely nothing for 6 years plus. We are renowned for taking a lot of time to do anything, to decide whether we're having a cup of tea or a cup of coffee at half time. Why? Because in too many occasions, ministers just sit and do nothing. If it's been in a pipeline for the last 6 years, how come we have not got there? Because nobody has fully committed to it and made sure that all these bits that need tying up, that need mending, that need putting together, all of those bits at least started a long time ago, and we got a chance of getting there. We could, if we choose, make up for that lack of effort and accept this proposition, even with the time scales that it has, which feel somehow wrong, but only because we've got used to nothing happening. We could say, let's get on with it. At least there's two times when you should do something, isn't there? One was at some time in the past, and one is now. The time is now to get on with this. Thank you.
Does any other member wish to speak on this proposition? Deputy Guida.
As I was considering whether to talk or not, but the previous speaker gave me a very good reason to do so. I find deeply offending for our team of lawmakers what he just said. Creating law is not just the will and the pen of one person. It takes dozens, sometimes hundreds of people to happen. In all places, there are several in this room right now. Those people are implicated. They participate in creating the law. All together, they do it. It takes years. And of course, it is unbelievably frustrating. Of course, it is very difficult. But why imagine that it is less frustrating to the minister who is trying to drive this and obtain those laws? I'm looking at my own list. Do you think it was not frustrating for me to see the prejudice crime law disappear? One of our major works for the 4 years, something that we've worked every week, that we've advanced every week, and then we're told, well, there are some very good reasons why we cannot deliver the prejudice crime law, the hate crime, for those who don't know, the hate crime law, this term. And what should I do? Should I come to this assembly with a fantastic proposition saying, well, if you just vote it, it's going to happen. If you just vote for this to exist, then it's going to happen. Is that all I need to do? Because I had no idea. If that's something I can do, I'll come back tomorrow morning and say, well, lodge in extremis something, and this assembly will make it happen. This assembly will make it exist. Huh? What about the sexual offences law? So we come up with one of the recognized as best written laws in Jersey. It was really good, fantastic law, superb. It was scrutinized, it was looked at, it was perfect. Very easy to read, very easy to understand. I was delighted to present it to the press. It's got a mistake in it. There's a massive failure in it. And that's something that urgently needs fixing. It's incompatible with one of our laws. One of them needs changing. And this is very important. This is primordial. We can have cases now where it says, this law says this, that law says the opposite. What do we do? Was that not urgent? Was that not desperate? Was that not something that we absolutely needed? Should I have come to this assembly to get this assembly to make it happen by magic? Because the 100 people working for us in all those departments could not, and everybody wants this. It's something that's needed everywhere. What about post-custodial supervision? Right now, when we're finished with a prisoner, we just kick them out. That's it. Have your life, see what happens. In every other country in the world, they are supervised. They are reinserted. We're one of the very few countries we don't have that in our legislation. Wasn't that important? Wasn't that something that we needed to happen? Should I have come to this assembly to ask for the special sauce to make it happen? Public entertainment regulations. You will enjoy this one. It's been 30 years. It's been 30 years since the bailiff has to organize and regulate public entertainment. And doesn't really want to, if I understand it. We should have a proper law that manages this. It's been 30 years. We were desperate. Len Norman put it on the top of his list and said, it's over. I'm not coming back to the bailiff every 3 years saying, that's yours again, you deal with it. I want it done now. Well, sorry, COVID happened. Our law drafting capabilities just collapsed during those 4 years. And this extremely important change, which is not terribly complicated, is just not happening. Tiny bits of law. Prescribed jurisdictions for the sex offenders register. This is tiny. This is a small thing, but it's very important. It means which jurisdictions we can exchange our sex offender register. So if somebody moves to Jersey from Guernsey, we can know whether they're a sex offender. That's reasonably important. Not terribly complicated. One of our priorities on my list every week since I was the Assistant Minister for Len Norman, every week, and advancing every week. And sorry, we cannot do it this time because we are doing everything else. We are doing all the stuff that are really going to be changed. Oh, sorry, unless I ask the Assembly, of course, because this Assembly can make miracles. Backing of warrants. The bailiff will know that this is something that they've requested that they find very, very important. Backing of warrants from other jurisdictions. Yeah, sorry, can't do it unless I ask the Assembly. And that's, all these are things that started before our term. Len and I didn't bring any of these. These are things that happened before our term. They're not things that we decided 6 months ago and we rushed and we really wanted to do it quickly. No, they're at least 4 years old. And all those things we have to give up. We had to give up because there is only so much that law drafters, that the law officers, that everybody that is involved can do. There's only so much that they can do. Unless you ask the Assembly, because they seem to have this special way of making stuff happen. So, about this particular law, I was shocked. And I must say, it's quite remarkable, because it does happen once in a while, where you say, my God, is that even possible? Sorry, married women are domiciled at their husband's domicile. They cannot have their own. You know, thank God we're changing this now. Thank God. Same-sex couple cannot appear on the birth certificate of a child. I wouldn't have invented it. You know, I couldn't imagine it was true. Of course it is important. And my guess is that if the right law comes in, it will be voted at unanimity by this Assembly. And I'm talking about the next one, an Assembly that will be different. But I can bet that it will be voted at unanimity. The only way people would not vote for it is if it was poorly written, if it contained mistakes, if it contained problems that couldn't be solved. So rushing it, bringing the wrong thing to the Assembly is the only way to risk it actually not being voted in. Whereas doing it the right way, without the special assembly source that seems to do miracles, doing it the right way, it's in the pipeline, it's planned for the next assembly. Nobody, I will bet with the people involved, that nobody in those seats in 6 months' time will vote against it. We all agree on it, but it needs to be the right one. Thank you, sir.
Does any other member wish to speak on the proposition? Senator Pallett.
Thank you, sir. This is my first day back in the Assembly for some considerable time, and I've had an enjoyable day. I've missed the theatre. I've missed the cut and thrust of looking people in the eye. What I haven't missed is being at home, listening to this through my computer and banging my head against the wall, which I can't do here. But nevertheless, it's been a good experience. I'm going to start by saying I'm going to support Deputy Doublé with this. Because it's the right thing to do, and everybody said they're shocked by what they've read and what they've seen and the emails that they've had sent, but they'll vote against this because, we haven't had time to do this. Well, I'm sorry, that just doesn't stack up. What really annoyed me is any suggestion, and I'm going to look Senator Messick in the eyes when I say this, and I don't need to stick up for him, but do any of you realise when he actually left office? He left office in government 16 months ago. There's been 2 ministers since then. They've had 16 months to sort this out, and yet we're still in a position where Deputy Doublé has had to bring this proposition to finally get this over the line. And that is an utter disgrace. I wrote some words down, and I was only going to use these words until people went on and on and on about how hard this was and how difficult it was, and all the time that law draftsman needs, and I'll remind people, 16 months. Prioritise. I had a quick discussion with my colleague sitting next to me, and the words that came out of our mouth at the same time was, why can't you prioritise? Deliver. Deliver something. You've had 16 months since Senator Messick, you're going to use him as an excuse. Sorry, sir, through the chair. 16 months. Why couldn't you deliver it? It's a commitment. Everybody's admitted this has been a commitment for 6 years, yet you've not delivered it. So why? There is no reason. I've got respect here, because this just stinks of a lack of respect for those same-sex couples that have had to live through this for a long period of time. We need to get that respect back, and if we have to lodge something quicker than maybe we like, then so be it. But we should still do that. And on the not done list, leadership. Being a minister is not easy. I've worked with ministers. It's not easy. I accept it's not easy, but they're there to lead. I've worked with some really good ministers. I'm looking my former health minister in the eye, and we didn't agree on everything, but it's a difficult job, and they have to make tough decisions, and you have to prioritise. So prioritise. Get the job done. There's been too many excuses. It's failure. It's spin. And it's also not putting children first. So come on, let's support this. Let's ask law officers to get this work done quickly, because we've done it through COVID and we know we can do it. So let's do that. Let's get this debated, and let's get this. Don't do what has happened too often recently, is kick the can down the road again to the next government to sort out. Let's this assembly sort it out, rather than expecting the next one to. So please, please support Deputy Doublé with this.
Senator Mezek.
Thank you, sir. I'm going to start by getting the emotional bit out of the way, and then move on purely to what I think are the facts that we can observe and comment on before us. And that first point to make, sir, is that I support LGBTQ+ rights with every fibre of my being. In this day and age, every single person in our society, irrespective of what their sexual orientation or their gender identity is, has or should have the right to live with happiness and thrive as much as everybody else. And our law ought to reflect that. And I'm very proud of the incredible progress that we have made in recent years, not just in changes of societal attitudes, but also in the legislation, which I'm very proud to have played a small part in bringing that first proposition on marriage equality to this assembly. But even with that progress which has been made, we should make it our mission to expunge every single vestige of homophobia which is still on the statute books. And let's not pretend that that will always be easy. There will occasionally be times where legislation is written in such a way where it's a bit complicated, or where it refers to lots of other pieces of legislation, and it can take time to collate that and fix it. And in the time that it takes for that to be done, there are families out there who don't get to be treated with the respect and dignity which they deserve in a modern society, and they must always be at the forefront of our minds in this. And so this point of principle of ensuring that same-sex parents are treated completely equally when it comes to the recognition of their parenthood of their children is one of fundamental principle that I am 100% behind, and I'm very pleased. And I'll say I'm not actually surprised that those who have spoken against this proposition have caveated their position by saying that they are also in favour of that principle. I appreciate that, and I take that as sincere, that there is genuine support to see this change done. So it becomes less of a debate on why and more on how. How do we get to that point? And so I am actually not going to have a go at the current Minister for Children and Education. He did make a comment in his speech, a comment which was also made by the Social Security Minister, to suggest that this issue predates them and that, in actual fact, it comes about from my time in office, which I do disagree with. And you may say, well, he would say that, wouldn't he? But I think the facts are on my side there. When I took office as Minister for Children, in recognising that we have to put children first, and that means recognising that not all families look the same, and that the children whose parents are same-sex should have equal rights to any other children and should have the protection in law that offers them, that must be in our legislative programme. And I promised when I took office that within a few months I would publish the Children's Legislation Transformation Programme to set out what that work programme would be. And it's a comprehensive work programme, some stuff which will go on into the next term of office and not be able to be dealt with this one. And I will point out that the line in it which talked about parental rights and addressing this was in commencement phase 1. Not any of the later commencement phases, it was in commencement phase 1, because it was always the intention, accepting that sometimes legislation can be tricky to get right, that it was always the intention that it would be done before the end of this term. That was the state of play at the start of my tenure, and it was the state of play at the end of my tenure, and I believe that it has been the state of play through much of the tenure of the current Minister for Children and Education. And I think that that is evidenced by the fact that the law drafting instructions were signed off in ministerial order in April of last year, at which point there is no sign that any disruption to that timetable had been noticed or recognised. If it had been noticed and recognised at that point and had been made clear, then perhaps we could have had a discussion and perhaps we could have managed expectations on that basis. That would have been a difficult thing to do because it will have meant potentially saying to those couples that they would have to wait longer to have in law the rights that they should have, or it would have given us time potentially to come up with another political solution to it. But I suspect that the Minister didn't recognise it as a problem at that point, and that perhaps further complications have arisen or that have been identified at a later stage, which makes the proceeding with that piece of legislation according to its original timetable difficult. Now, I will not criticise the current Minister for that, because sometimes those things happen and they're unexpected and they're extremely frustrating. And I had a great deal of sympathy for the comments made by the Home Affairs Minister, who has had aspects of his legislative priorities disrupted for various reasons. That must be extremely frustrating. And let's not of course forget that we have had a pandemic thrown into the middle of this, which has disrupted a lot of things as well. So the question now is, in recognising that something has happened somewhere along the way, and who is to blame for it is frankly irrelevant, and I suspect actually nobody's to blame for it. It's just sometimes you uncover things when you take on a piece of work that you weren't expecting. And in fact, often that can be more likely to arise towards the later stages of the work rather than at the beginning, because of everything else that crops up along the way. So the question now is, what do we do about it? Can we still meet that deadline? And if we choose to meet that deadline, what do we have to do to make sure we can? And notwithstanding the argument that has been made by the Minister, I find it impossible to justify voting against this on pragmatic grounds, on the basis that perhaps if we wait a bit longer, we may get the law right, and there may be a risk of not getting it right if we aim to do it sooner. Because I think that this Assembly and the law drafters, through the pandemic, showed what they're capable of, showed how we are actually able, if there's a will to do so, to respond to these things quickly, to dedicate the priority to them that they require. And sometimes that can be awkward. Sometimes it means some people have to work hours that they hadn't anticipated working on. Sometimes it means you have to perhaps shift something else to the side. That's a matter for politics to decide whether it is worth the prioritisation. And if some members want to say right now it's not worth the prioritisation to get it done, well, so be it. But that's not my judgment. And it's not my judgment because I think that with the best of intentions up until some point very recently, this was what we intended to do. Something has happened somewhere along the line to disrupt it, and those expecting children do not deserve to have to wait longer to have their rights accepted in law. And we've seen the communications we've received from people who are facing those situations and from the loved ones of those who are facing those situations, that I think it is right to say we will do what we can to reprioritise that, notwithstanding everything that's gone up until now, to try to meet our original promise to those people, which was that this would be dealt with during this term of office. Sir, I'll vote in support of this proposition. I urge other members to do the same. Let's not play a blame game here, because that shouldn't be what this is about. This is about whether we uphold that promise to a group in our society which for hundreds of years was marginalised and discriminated against, but which we are making incredible progress in recent years to try to overcome that and expunge the vestiges of homophobia from our legislation. So, sir, let's get it done and support Deputy Doublé.
Very much, Senator. Deputy of St Mary.
Thank you, sir. I'd like to begin by endorsing the final comment made by Senator Messick that we're not here to play the blame game, and I cast no aspersion on anyone what I'm about to say. Deputy Doublé, in her original speech, made reference to the Law Commission. That's not been mentioned since. She's right. The Law Commission did make recommendations as to where Jersey law was deficient in certain areas and recommended a certain course. There is a body in this Assembly, the Legislation Advisory Panel, which is appointed to take forward recommendations from the Law Commission, and I'd like to think that in ordinary circumstances we would be able to do that. Unfortunately, the LAP has been effectively deprived of resources during this period, and we've been able to do very little. The LAP, for those that don't know, is effectively the successor to the old Legislation Committee. It is presently composed of one minister, a constable, a senator, and 3 other deputies, all of whom were appointed by the Chief Minister, all of whom were fully aware of what they were taking on, and all of whom were prepared and willing to consider and put through legislation such as this. We've been able to do so for reasons of lack of resources. And I flagged that point, sir, because I think Deputy Young did say in his speech that there should be a greater balance between what he termed sort of social legislation and that required for the finance industry. I don't disagree with that, but I certainly would not be, as chair of the Finance and Economic, chair of the Economic and International Affairs panel, I would not be supporting any reduction in resources available to that department. The legislation there is crucial, but so is social legislation. There needs to be a better balance, but that is to be done by increasing resources available to put through social legislation. Again, in this connection, I'm sorry that the LAP were unable to assist the relevant minister on this occasion. I like to think that in any future government, LAP will be regarded as a valuable resource, an independent resource, and one which can get things done, crossing through party lines, and will be in addition to the input which ministers are able to perform. So having done my plug for LAP, if I may, sir, as to where we are with this proposition, I think everyone is right in saying that there's no resistance to what is intended here. It's really a question of as to what we can do at this stage. Again, wearing my LAP hat, there was one situation where the Stark option was put to us. Do we want to wait for the next term to put something through in final form, or do we want the Lord Russman, or whatever their current name is, to do as much as they can in the circumstances and see how we go? The panel elected for the latter, but in fact that didn't come through either. So I think my inclination now is to support Deputy Doublé's proposition, request the Lord Russman to produce something, and if it is seen to be deficient, or there are areas of deficiency identified during scrutiny, they will be revealed to the Assembly and we can take our decision at that time. But I think it would at least show the mood of the Assembly that we are not ignoring this, we wish to take it forward. And with that, sir, I shall be supporting the proposition. Thank you, sir.
Very much, Deputy Connie Tarver, St Mary.
Thank you, sir. I think we have all been inundated with emails on this issue. Gender has nothing to do with this proposition. People have a right to live with whoever they choose. This is about the rights of a child, something that most of us have signed up to defend. This proposition needs to be adopted. This is a people's choice that complies within our laws. Maybe this could be further refined, and if it can, that can be done at a later date. Now is the right time and the right thing to do. We are not a dictatorship to deny this. Thank you, sir.
Very much, Connie Tarver. Deputy St Martin.
Thank you, sir. This is a very difficult decision for me, and I know for all members. We absolutely know what we want to do and achieve. But today we're asking, is it practical at the present time? Is it going to be safe? What might be the consequences of trying to fast track a usual process? We absolutely share the sentiment behind the dozens and dozens of messages we've received from the public, many of which have been identical, but that is what they wished to share with us. But there was one that I thought was particularly incisive, which we all received at 11:38 today. And it begins, I appreciate the list of laws needing to be updated must be very long, and for some of you these will have a higher priority. But I would appreciate your support of pushing the parental rights law change through. And I thought that there was some understanding there of the difficulties we find ourselves in. There was a recognition that the lawmaking process is important to establish the rights and duties in every respect as an islands legislature we wish to give, and to set up that framework of rules under which we want to live as a prosperous society. That email recognised that there was a long list of laws awaiting debate in order to achieve that end. And it recognises that some may have a higher priority. But how do we determine that priority? Because there are competing priorities. We all want things to be achieved. And absolutely I share the frustration expressed by Deputy Young and Deputy Guida about the length of time that we take to achieve what we want to achieve. And wouldn't we all love simply to wave the magic wand and have it land on our desks? But we also know it's important to be thorough and to make sure that we get this right. And we don't create something which only causes further problems and upset and distress down the line. Because there is a list of priorities which is determined as a result of states' decisions and as a result of the government plans and as a result of ministerial directions, and the law drafters work to that. And like Deputy Guida and Deputy Young would have wished to bring forward their priorities, I have priorities in healthcare matters as well that I would have loved to have seen legislated for. There are islanders who have been injured and harmed as a result of unregulated persons offering therapy in this island. There needs to be all sorts of things that we need to legislate for. This is one of them. This granting of parental rights, this protection for children, it is sorely needed, and families deserve this piece of legislation. But the difficulty is if Deputy Young and Deputy Gida and I and other members start throwing in what they would wish to achieve, then we end up in a state of total confusion. It is clear that this law is being prioritised to the maximum extent. Deputy Dublé was gracious in thanking all involved. She is not saying that either Deputy Masson or Deputy Wickenden have taken their foot off the accelerator. But yet, and I was disappointed with this, she appears to think that the intention is to discriminate against a group of people who have been marginalised in the past. But that doesn't marry up with what she said in offering thanks to everybody who's been working on this and accepting that it has been treated as a priority. So I thought that was an unnecessary remark to me.
I believe the Minister is
I'm
misrepresenting
sorry,
me.
what are you standing for, Deputy Dublé?
Would the Minister give way?
Yes, sir.
He's stated that I've said
Is it
that...
a point of clarification you're seeking?
Yes, yes. Could I seek a point of clarification? The Minister is stating that I've said that we are seeking to discriminate against LGBT people. I haven't said that anybody is seeking to discriminate, but what I have established and what the Law Commission has established is that the current law actively discriminates. I'm not saying that states members are doing that. I'm simply saying that the law does that. So if the Minister could clarify that, I'd be...
Well, I don't think the Minister needs to clarify. You've said what you think the position is. But of course, you will have a speech in response at the end, Deputy.
I'm very grateful, sir, that Deputy Dublé has clarified that it is the existing state of the law that is discriminatory rather than any actions on the part of either ministers or officers, because that is certainly not the case. What we have here is a piece of work that is highly complex and technical, and there are risks if we do not get it right. And the risks can have far-reaching consequences to children and families and could create harm down the line. So those review processes that are part of the standard procedures are really important. It is important that the people who will be using this law, that will be at the sharp end, deciding whether to confer the rights that this law might give, are consulted, are involved, are to look at what comes through the drafting process. This might be the family court, for example, and to know, to be assured from all their experience, because it's those people working in the family court that have that experience, that this piece of legislation is workable and will do what it is intended to do. Sometimes it's difficult for us as politicians, even for law drafters, to understand what the provisions will do, because they have not previously met the examples, the real-life situations that the law is intended to deal with. So how important it is, and we must not just cancel that process because we need to bring something here to this Assembly within a timescale that is only governed by our electoral period. So the comparison was made with the speed at which we enacted COVID legislation. If you remember, sir, the primary law we used for COVID was very brief. It was on a single side. That's the primary law. This is primary law. Most COVID legislation was regulations, which were longer than the primary law, but they had a limited life. And they were rushed through because we had to rush them through, but as we worked with them, as our COVID teams did, and as a minister I saw this happening, we saw gaps in them. There were gaps. If we'd have had the time, which of course we didn't, they would have been better regulations. They would have been more effective in doing what we did. If they were to have been permanent regulations, they would have been drafted differently and with greater process around them. Because, it's, as Senator Mezek said in his speech, as you go through law drafting, things are uncovered, issues are uncovered as you plot your way through the consequences of each of the clauses you are drafting. And those things that become uncovered, which Deputy Wickenden is talking about the issues around not having the Human Embryology Act, the domicile of origin issue. They're highlighted to ministers and officers what needs to be done, what's the policy direction on this. And that needs to be thought through, taken away, and the drafting work its way through to ensure that no lacunas are created, that every consequence is covered, so that we properly protect children and families in this area, and so that we achieve what we want to achieve by this legislation. So I can well understand why it is that these things that have become uncovered at this late stage are absolutely important to deal with. It is not appropriate, I think, for us to say, don't worry about them, just push it through. Just put something before this assembly that we can press our buttons on. Because we create so much risk. We risk the harm to the people we want to serve. We've made that rule that nothing should be lodged after March the 10th. So, of course, nothing. The state it's in at the moment, I don't believe that the Education Minister is capable of bringing something by March the 10th. And I hope he doesn't try and do so, understanding the problems that he's described. He said he would endeavour to bring something to this Assembly if this is what the Assembly wishes. But we know that to do so, there would have to be shortcuts. There would have to be risks taken. That review process, that consultation with the people who are going to be using this law will be curtailed, will be cancelled, whatever. I don't think that should happen. I think we should aim for getting it right. And I'm sorry if that disappoints people, but where else would we say, let's do something like this, cutting the process short? It's only because we have an election period coming up. We're told that this will arrive by October. And of course I'd love it to be sooner, like I'd love all the other legislation we need to be sooner. But if doing the right thing means October, why are we letting our election fever shortcut all this and accelerate it dangerously? And what work is being set aside if this has to happen? That we don't know. What urgent piece of legislation that might be being worked on right now is going to be dropped if this Assembly decides to go ahead? I don't know. So it's our decision today whether to accept the risk of enacting flawed legislation, whether to fast track it because we've got an election, or is it best for the people we serve to know that the legislation that we debate is right, has been consulted upon, it's been checked and reviewed, and it will achieve what we want to achieve? So I say, let's go for the latter, because we should not be a legislature that acts in any other way. Thank you, sir.
Very much. Senator Farman.
Thank you, sir. And I never like to be in a juxtaposition with fellow ministers. So occasionally it happens on certain issues, and there are certain issues such as this that I think transcend political and party boundaries. And in the spirit of what a number of other members have said today, we often have to strive to work harder together, to share the burdens of responsibility as an assembly and not try to apportion blame to certain ministers. And I refer to the current and past ministers who have had responsibility for these important areas. And I do feel I think I've made myself a little bit unpopular with some colleagues, and I must apologise to Deputy Wickenden, sir, because I seemed to contradict him yesterday when he spoke about the rationale for not debating this, for not allowing this to be debated early, sir, and I spoke against that position. And I did so only because I felt not allowing this, sir, would be kicking the can down the road. I felt the Assembly needed to debate this. It's an issue that's been simmering for a long, long time. And any further delay would not have been in the interest of this Assembly or the people we are trying to assist, and for a number of other very good reasons why we need to ensure our legislation removes any sort of unfair law that still actually has managed to stay on the statute books. And I know the amount of work ministers do and previous ministers have done, so I can't stress enough the thought and the very, very good intention that have gone into getting this progress. And it has been, I think it's been simmering, it's come on and off the boil. But there are very good reasons for that, sir, not least the really difficult other political and geopolitical issues we're having to deal with as an island and as an assembly. And as other members have said, so we all agree what we want, and it's going to happen. So whatever happens, whatever the outcome of this debate, I think this issue has been prioritised, it's been moved further up the list, and it's going to be achieved. And let's be clear, sir, we know there is a real and genuine intention of the current minister and assistant minister to do this, sir. And Deputy Wickenden has said, and he's made it absolutely clear, that if it is the Assembly's will, he will do everything in his power, sir, to deliver this, despite it needing a very late lodging time, sir. And I'm presuming, sir, you can only adjudicate on that when you've seen what is put before you, ultimately.
Well, I think that must be right. Just to interject, a standing order requires me to consider, if it's after the 10th of March, whether I can appropriately permit it. And there's a test, which is that I must be of the opinion that it relates to a matter of such urgency and public importance that the lodging should not be delayed. That is, I think, I need to see what I'm being asked to make an adjudication upon before I make that decision. Inevitably, that must be the case.
Thank you, sir. And I think it's important that members do realise that. But I know, sir, that I don't think any minister would bring legislation or allow legislation to be tabled that was unfinished or unsafe or poor in any way, sir. And I know this Assembly would not pass any legislation, sir, if it was not in a fit state to be accepted, sir. I'm not even sure if you, sir, or the presiding officer at the time would allow it to be tabled if there was any uncertainty over its fitness for use. But what I do praise the current minister for is that against his when I say judgment, sir, he is concerned. He doesn't want to bring anything that's not right, sir. He has said if it's the will of the Assembly, he will do everything in his power to deliver that. And I believe him, sir, and I want him to support him in that endeavour, sir. I think we must try and do it. We can move heaven and earth when we want to, sir. And we've done it before, and I think there's an opportunity to try. So why don't we try and do it, sir? But there is a caveat, okay? And that is that there can be no retribution. If it's just not possible and it can't be delivered, or it's delivered and it's deemed not to be finished, and it can't be tabled, then there can be and there should be no retribution, as long as the Minister and the team, sir, and those officials involved have done their level best to bring it, sir, as the Assembly has asked. And I will be asking Deputy Dublé to confirm that, that she understands that and is looking to see the effort, okay, prior to the result, and hopefully the result as well, sir. I think, to reiterate, sir, sometimes we have to share the burden of responsibility as an Assembly and not put it all on individual ministers for certain policies, sir. And of course, when this Assembly, one of the great things about this Assembly, sir, is that when a member doesn't agree with government policy, a member can bring a proposition, any member can bring a proposition, sir, to seek to change that. That's quite right. That is democracy, and that is how it always should be. So in the spirit of cooperation, let's give it a go. Let's see what we can do, sir. And I'm going to support this proposition on the understanding, sir, that there will be, if it's just not possible, there will be no retribution. There will be no attack tax on the Minister. There will be no looking for revenge, sir, because ultimately, whatever happens, sir, we have actually given this a far greater priority, the priority it deserves, sir, and after many years, we are far closer to achieving the legislation that we need than we ever have been. Thank you.
Very much, Senator. Does any other member wish to speak on the proposition?
Yes, sir.
Chief Minister.
Yes, thank you, sir. I think we are all in vehement agreement that this law does need to be passed. Can you hear me, sir?
Yes, we can hear you quite well.
Okay, thank you, sir. And what has become very clear, and I've obviously been getting up to speed on the issues surrounding the delay on this in very recent days, sir. It's very, very clearly a incredibly specialised area, as has been alluded to already by both Deputy Wickenden and the Deputy St. Juan. And I think what is also we do need to emphasise, sir, is indeed when that extra. Sorry, sir, I'm getting an echo somewhere.
I'm sorry, I'm afraid I'm speaking without having turned my microphone off, but I wasn't speaking to interrupt you. Please carry on.
Apologies. Okay. We did actually put extra resources into getting this law drafted. So it's not for lack of will, sir, that we have arrived in this position. And indeed, I think Senator Messick has identified that as far as he is concerned, it was in the programme of works. Let's be very, very clear. Deputy Wickenden and Deputy Masson signed off on this when it was brought to their attention in April of last year. So this has been around for a long time. I think we also need to be very clear, there's no criticism of law drafting, sir. Law drafting is not under the control of government. It sits under the GREF, basically. It's a non-ministerial department. It can actually seek, if it needs to, I might regret saying this in the future, sir, to put extra request in the government plan for extra resources. It does not need, if it wishes to. And so there's, but it is also an iterative process. So law drafting instructions go to from the Minister to law drafting, and then as issues are identified, they will go backwards and forwards. I think what we need to be very, very clear on, which a number of people seem to have forgotten, is the impact of the pandemic. I make no apologies for repeating that again. Essentially, the pandemic, if you like, crushed the original programme of work that we had. It has taken 18 months out of the programme. And nevertheless, sir, certainly the last update that the Council of Ministers had, which was basically at the beginning of February, was that this would have been lodged in time for debate before the elections. But what has come clear, sir, is that firstly, there have been foundations that have had to be put in place. So certain laws, particularly involving single-sex parents, but to get foundations in place to enable, for example, this law to occur. I believe, so I'm informed that examples of that, for example, were ones that we approved today, which was P6 and P7, for example. But what then took place, that with the specialist advice and resource that's been put there, is that at relatively last minute, greater technicalities arose, and I need to be very clear. The advice that has been relayed to me through officers from law drafting is that it is, and it's strong advice, that it's going to be very, very difficult, potentially not feasible, because of the technicalities that have now arisen, to have a robust law in place for debate by April. I do absolutely agree, sir. If we are very much in the hands of the Assembly, I will listen to Deputy Dublet. I will almost certainly not be supporting the proposition. I'll work out what's left in terms of how I vote on it. Principally, sir, not because I don't agree with the principles behind what the Deputy is proposing, but particularly, and I think far better enunciated through, for example, Deputy St Warner and Deputy Wickenden, bad law is bad law, and if we line ourselves up for bad law, then actually it's the people we're intending to help that ultimately will suffer. And so, sir, that is the advice that we've been receiving from law drafting, that no matter how much the will is there, these technicalities have caused a delay in the complexities of drafting this legislation. It is nothing to do with ministers in any shape or form in terms of interference in that process. I think, sir, I do need to address one or two aspects. I'm glad Deputy Dublet did clarify her comments, sir. I do have to say, I will go back and listen to Hansard, that certainly what I interpreted her to have said is that there'd been, I don't know if she used the word deliberate or not, but a marginalisation on the particular groups who were minorities, and basically, sir, in this area. And so I'm glad she clarified that remark, but I think we should just, perhaps she could check Hansard as well, if she wished to clarify the position. I don't think it was relative to the law, but anyway, let's see what she said on the record, sir. I think, sir, I do wish to address, there's been an inference, I would suggest, that nothing's been happening in terms of children and putting children first, sir. Well, we've had P107, the Draft Children's and Young People's Law, sir. We've just had P9, and we're going to be debating P19, sir, which is the Convention rights, sir, and with due regard. And that's quite a significant improvement, in my view, of children's rights. So, sir, I would very much refute the suggestion, or any suggestion, that this government and this Assembly, sir, has not been doing its utmost to improve matters for children. But we've also said we are starting from a low base, and as Senator Mezek said, there is a long programme of work we've got to do. So, sir, I think the point, sir, there is Deputy Massel, I think, said it absolutely correctly. He and Deputy Wickenden were absolutely behind getting this law in place. I think we're all disappointed in how this has panned out. But I make the point, sir, we have had 18 months, 2 years taken out of resource because of everything we've had to do on the pandemic, and that has had consequences. If, which may well be the case, the Assembly does vote for this proposition, sir, we need to be very, very clear, if it is lodged, subject to all the things that you, sir, will have to approve, it will almost certainly be a very shortened lodging period. And we have to make sure, where Deputy Massel is absolutely correct, this has to be got right. The grief and stress that will be caused if there are errors in it which subtly come out, sir, I think will probably outweigh a delay if it went into, for example, October. Sir, so the risk of error is high. I want to pick up one more remark, sir, from the Commandant of St John's. He made some remark about the Children's Pledge, sir. Well, sir, there are two approaches. You can either sit and ask and wait to be asked, sir, or you can reach out to the Minister and perhaps ask how to sign it. And I would suggest that the latter might have been a more productive approach. So what I think, to conclude, sir, I think it was Deputy Massel's request, which I definitely put towards Deputy Dublet, is why actually she is suggesting that the consultation that is being referred to, Deputy Wickenden laid it out, which is about, for example, the Family Court Service, the Judicial Graph, Children's Commissioner, and others. Why that process should be curtailed in what is becoming clear is a very, very complicated area. I'm not a lawyer, sir, very, very clearly, but that's the advice we've had, and I do know that we've had a lot of discussion around legislative scrutiny, and I do believe that getting this correct in this instance is worth that delay, that unfortunate delay. It is not something we would like to see. We would very much prefer to be debating this in the next 2 or 3 sittings, sir. But that is the advice we've had, and that came through very short, relatively short notice, basically in the last 3 to 4 weeks. And I understand, sir, it was raised for scrutiny towards the beginning of February, basically as soon as it came out. So, sir, I will listen to the closing remarks with interest, sir. I suspect I can see the way the Assembly will go, but I think, as Senator Farnham said, we need to be very clear that whilst we have, we'll do our absolute utmost to try and respect the will of the Assembly if that's where they go, there should be no retribution, as it were, back on the Minister on the basis that we've been very clear, sir, that the advice we are receiving, it is an incredibly complicated area, or technical areas that have arisen, and that those technical areas will take some time to resolve. It is not a lack of will, particularly on behalf of the Children's Minister or even the previous Children's Minister, but it is a matter that is extremely unfortunate and has arisen in the last 3 to 4 weeks. On that, sir, I shall listen to the closing remarks with interest, sir, and ministers are very much in the hands of this Assembly, sir. Thank you.
Thank you very much, Chief Minister. Does any other member wish to speak? Deputy Pamplin?
Thank you, sir. This has been a fascinating debate to listen to, and I have a few things I'd like to reflect on that's absolutely relevant to the debate. 4 years ago, in the induction period before taking the oath of office, New States members were invited to inductions and various meetings to learn what's ahead of us for the next 4 years. When I look back 4 years ago, some of it was obviously very appropriate. None of it obviously could have predicted what we've all been through the last 4 years. However, I was struck by a couple of things. One was the briefing we had from the Law Officers Department, and we all descended into the room. There was more of us than there was of them, which struck me as interesting straight away. And to hear such comments 4 years ago as, well, one of us is leaving, one of us is only here for a period of time, we are struggling to recruit people. And I was sitting there thinking, this is the fundamental part of the reason why we are here, is to move as quickly as we are shown we can as a modern society, to ensure laws are debated and drafted that the people who put us here want to see being passed. And that is an issue that I think that has been a problem in all the changes that has happened around this great assembly over recent years, the introduction of ministerial government, the introduction, the loss of the committee systems, the split and the divides of this assembly, which I still think don't get talked enough about. And for people listening to this who are thinking about standing in the assembly, I think this is one of those important occasions to listen very carefully to some of the things that are being said. To tie this into this proposition, it's one of those rare occasions where you agree with everybody and their positions. However, the one speech in particular that struck me, and that was once again the wise words of the Deputy of St Mary, who always in these moments puts forward a very sensible, pragmatic and reasonable speech together that in few words captures what I think is where the emotion of those people who are reaching out to us, who want us to act. And I think that's the key here, is adding the pragmatic approach and taking the challenges and the legitimate problems and concerns rightly described to us by ministers of various departments and trying, because a large group of people have reached out to us. There's been many debates in the last 4 years, sir, that members of Islanders have reached out to us. Hospital, I guess, would be the big one. But I can't recall over the last couple of years, there has been a lot going on, where a large amount of emails have been pinging at such a considerable rate. And I only wish and raise that it just goes to show that how important it is that members of our society who passionately believe in something that's important to the people that they represent, that you can have that connectivity with the people who decide the laws of this island. And I wish other members of this of the island would recognise that there is a way to connect with your politicians. Don't just wait every 4 years at the hustings and the vote box. And I applaud all of those people who have reached out to us, because at the end of the day, we are here to connect the challenges that have been, the technical challenges have been put forward with those of a community who are crying out to us to try and do something. After all, perfection is the enemy of the good. Speed does trump perfection. The greatest error is not to move. The greatest error is to be paralyzed by the fear of failure. If you need to be right before you move, you will never win. In the current climate that we are all in and watching at the moment, is a group of islanders want us, and I don't think it's anybody's intentionally doing this, it is a perception of a feeling that a group of people, that's how they feel, and they feel that this has been a problem for many years. We have an opportunity. It may be, as others have said, when that is put forward, it is not something that we can put forward. But after all, this is the assembly that will make that decision. We should try, and that's what I believe we should. And to other members who feel very passionate, well, we could have done this many times over. So I believe in the spirit of that, I wish the Minister and the team all the best if this goes through. I have much hope and faith in them and everybody who could try and do this. And that's the message I want Islanders to hear. Thank you, sir.
Thank you, Deputy. Does any other member wish to speak on the proposition? Deputy St Martin.
Thank you, sir. Sir, I'd like to think every other States member like myself comes into this Assembly in order to try to do some good and to make Jersey a better place. And some days we go away from here uplifted and feeling as if we've done some good work. And then other days we feel, maybe like I do, disappointed in the way things have gone. And I was disappointed yesterday with the way Deputy Higgins spoke during his speech after such a good proposition. And I have to say I'm disappointed again today because Deputy Doublé has brought this proposition after the advice and the words that she's had from the Minister. I'm disappointed because the Minister has warned that there will be mistakes, there will be omissions, and there may be problems, and I'm further disappointed because of the reference to scrutiny. Put this in front of scrutiny and we'll move heaven and earth. But if the Minister's right and there will be mistakes and problems, the only answer for scrutiny really will be to call this in, and that will delay it further. I'm disappointed, sir, because this is not the way things should be done. This is not the way we do things. But why are we here? How do we get here isn't important. The important thing is, how do we move forward? How do we make progress? And I'm not going to be voting against the leader of my party because I really want to make progress as well. I'm going to be pushing the yes button, but I will be sort of holding my nose, as some States members have said in the past. Hold your nose and push the yes button. So it's really important we try our very, very best to get this legislation in place. And I want to move forward as quickly as I can. So I'll be voting in favour. Thank you, sir.
Deputy, does any other member wish to speak on the proposition? No other member wishes to speak? Deputy Tadier.
Thank you, sir. Sir, one thing that springs to mind, and it is linked to putting children first, although presumably we don't put all children first, just depending who their parents are. Others are given a lower priority. I'm reminded at the early stages of this current Assembly, we debated the Committee of Inquiry findings into child abuse. And there were lots of fine words around that. There were lots of talk about this must not happen again. And we then signed, or some of us signed, the Putting Children First pledge. And one of the recommendations, or findings rather, from the Committee of Inquiry was that the island would often be able to often talk about how it was very good at prioritising legislation that it felt it needed to, certainly around finance and around the needs of the finance industry, and that the government often boasted internally and externally about how quickly it could work to bring through legislation that was requested by the industry. Paraphrasing there, but that was essentially one of the findings, but that when it came to social legislation and legislation and protection and policy generally that affected children and families, it had dragged its feet over many decades. And so, of course, this is quite a tight deadline. One has to ask, of course, why it wasn't done earlier. But I think it is one that can be achieved if we all put our mind to it. And it would be a good example to show how ministerial government is so much better than the old committee system, which was laborious and onerous and took so much time to get things done. But actually, now we've got a ministerial system. The minister can just issue the directive, ask for all the relevant work to be done, and for this to be lodged in time. I don't know if it was addressed earlier, sir. Sorry if I missed it. It might require, of course, lodging periods to be changed. Whether scrutiny want to call this in, that's entirely within their prerogative, and that shouldn't be a reason to vote for or against this, because if scrutiny at some point want to scrutinise it, that's fine, but the proposition will be lodged and on the table, and we can judge, and all of us can judge the current government and what they've done and what's being put there on the table, sir. So I certainly, for one, will be supporting this because the principle of it is the right thing to do, and I commend the Deputy, who has always fought for children and equality and families to be treated equally, to make sure that their voices are heard. Incidentally, I think the reason we've been getting so much lobbying on it clearly shows that there is an issue that touches a nerve with the public that they feel strongly about. But of course, it's because we've got a new system in place where anybody in the island can email all states members at the drop of a hat, and it's easy to copy and paste messages nowadays, which then require so one copy and paste message, of course, means that 49 members have to respond to that one copy and paste message. I'll leave it at that. I think we can decide whether or not to support this. There's clearly a lot of sentiment out there.
Thank you very much, Deputy. Does any other member wish to speak on the proposition? No other member wishes to speak? Then I close the debate and call upon Deputy Doublé to respond.
Thank you, sir. This has been a long and interesting debate, and I do thank all members for their contributions. Some of the final speeches, sir, it was interesting because, and actually, to quote a word that one of the more recent speakers used, disappointing, actually, to hear some of the scaremongering that has been going on. And I think other backbenchers will sympathise with me, but also realise that perhaps that's when you know that you have done the right thing, is when the government start resorting to excuses, threats and scaremongering. And I do think the Deputy of St. One framing this issue as election fever, that surprised me, sir, and I think that was such a low blow. I have been pressing for progress on this for years, and the moment that I feared it would not be delivered, I came straight to this assembly. And the Chief Minister mentioned grief and stress that might come about if we get things wrong by rushing this law. To be clear, sir, I'm not asking anybody to rush or not do the work properly. We can't possibly make things worse, sir. Members have spoken about discrimination, and it's interesting that it's an almost offensive reaction to say, I am not discriminating against anybody as a States member. And of course, nobody intends that. And I myself, I didn't know that this legislation hadn't been changed, actually, last term. I thought it had been changed, and it was only when I was approached by a same-sex couple I realised it hadn't been. And it's not us as individuals who are discriminating, but the fact is there is discrimination built into our law. Senator Farnham mentioned the minister, and indeed I note that the tone of the minister's speech towards the end really sounded like he was genuine in wanting to support the LGBTQ+ community. And I'm really grateful to him that he is prepared to do everything he can to fulfill this if members approve it. And to respond to Senator Farnham, again, strange terms to use. I would not, of course, seek to unduly reprimand anybody, or I think the word he used was revenge, a very peculiar term, because of course we all have a level of professional respect for each other in this assembly despite our political differences. But Senator Farnham can be assured that Deputy Wickenden has nothing to fear from me beyond the usual democratic processes, and indeed from the members of the public who are pressing for this. I believe it can be done, sir. I have faith in the Deputy. I have faith in the Minister. I think he can do it. I know that the processes that we have, and again, some members have asked me to clarify this, I think that we can still ensure that those processes and those checks are carried out. I will reiterate the point that I have made. We did it during COVID. And of course, that was extremely urgent. I think this is an urgent issue, sir. It goes back to putting children first. And I found it so interesting that the Constable of St. John said that nobody has asked him to sign that pledge, because actually, and the Deputy of St. Martin will attest to this because he was in the coffee room yesterday, I found it upside down on the floor to one side in the coffee room, the big pledge that most of us have signed. And so I put it back up in the coffee room because it actually means something to me. I signed it, as most of us have. But I actually, even before we had this pledge, sir, and members have said this, I came into this assembly to speak for children because I felt nobody was speaking for children. And that pledge means something to me, and it should mean something to every single one of us. Deputy Ward was as passionate, I think, as I have been about this. I thank him for his support. Deputy Young, I thank him for his confidence. But I think he did reinforce the point that I was making about this being an issue of political deprioritisation. Because tenacity, that's a word that Deputy Ward used, tenacity is something that is required of a minister. And minister or backbenchers, whatever role we hold in this assembly, they're all important. And that tenacity is required. And Deputy Young and other ministers spoke about lists of things that they haven't been able to complete. And I sympathise with them. And I'm sure if I were a minister, I would be in the same situation. I'm sure I would be. But again, I go back to the point that I made in my opening speech. Children and family legislation should not be competing with some of these other areas that we have spoken about. We're either putting children first and we're prioritising all of this legislation for children and families, or we're not. Deputy Martin, I think in one speech said on one hand, she thinks that the next assembly will approve this easily and there's nothing to worry about because they're going to get it through. But she also said that this should be an election issue. And I find that confusing. And she also, the deputy mentioned that she didn't feel she believed in the urgency of this. And sir, I would like to hear anybody say that to the children who are affected by this, because actually I have had the pleasure of meeting some of those children, and some of them, even though they are very young, fully understand their situation, and they fully understand that the island that they live in and they call home is discriminating against them and denying them their rights. There was also some misunderstanding around there being a third parent. And again, I think it shows that our lack of understanding around some of these issues, it shows it hasn't been a priority, that it's a donor, not a third parent. The parents are the individuals who are raising that child. The Deputy of St. Peter and the kick he spoke about or was not allowed to speak about, that comes from the decision of this assembly. And that's why it's important that we do that we collectively come to a decision. And I hope he will support it. But if he cannot, then I agree he should abstain. I agree. In terms of consultation, the external consultation has taken place. What remains is the internal consultation. These are our processes, sir, and I will again take members back to the analogy I made about this big machine, which we are supposed to instruct. It's in our power to do this. Deputy Masson wonders why can't it wait till the autumn? Why can't these families wait till the autumn? Again, I would like him to ask that question of those families because, sir, they are desperate, and they have been desperate for years, and they have been terribly patient. And I think they are losing their patience, and they are right to feel it that way. Some of the scaremongering, sir, it actually reminds me of a recent debate that we had about Samurai Ward, and we heard these similar cries, didn't we, about we couldn't possibly do this, it just can't be done. And yet, sir, the Assembly instructed the Minister to do it, and it is being done. That's how democracy works. I thank Deputy Southern for his support. Senator Pallett, again, I thank him. He spoke of a lack of respect. Respect is really important, and I can tell you that the families in question are not feeling respected. We can restore that by approving this today. Senator Mezek, another pioneer for LGBTQ+ rights, and I know he shares my passion, as it seems does the Constable of St. Mary. So I know that lawmaking takes years. It has been years. Can I remind members that this law was on track for completion just a few weeks ago? There is a huge body of work already completed and behind this. The Law Commission have set out what needs to be done. We're not starting from scratch. And I think the final point I have to make in terms of prioritisation is that a lot of the legislation that was quoted as it's not going to be finished, and I share the Home Affairs Minister's dismay actually at some of that legislation that isn't going to be completed. And he might wonder, sir, the Minister might wonder why I've chosen this issue. And the reason is this. Much of our legislation, especially the Home Affairs legislation mentioned by the Minister, is about preventing or punishing harm being caused by citizens to other citizens. Okay? And it's hugely important. But the issue that we are talking about today is actually an example of where one of our laws that we are responsible for as the State's Assembly, as the Parliament, is currently actively causing harm to families. That's happening today to families, to children. That's on us. We have a responsibility to right this wrong while we still have the powers delegated to us by the people of this island. So I'm not asking for processes to be missed out. I'm asking that we press on, sir, with a piece of work that until very recently was on track. None of us know if we'll be here in these seats in a few months' time. We must think of, I think it was Senator Mezek made the point. It was Deputy Tadeo, actually. We don't just put some children first, we put all children first. And yes, this affects a small group of children, but We must right this wrong, sir, and I ask members to support this today and call for the appel.
Very much indeed. Invite members to return to their seats, and I ask the greffier to open the voting. If members have had the opportunity of casting their votes, then I ask the greffier to close the voting. Could you clarify your vote in the chat, Conetava Trinity?
Yes, sir. Apologies. I voted poor, please.
Thank you very much. I'll ask the greffier to close the voting. It's closed. So the proposition has been adopted. 35 votes pour, 6 votes contre, 4 abstentions.
Thank members for their support.
I beg your pardon, 2 people spoke at the same time. Deputy, did you want to?
Yeah, could I thank members for their support?
Yes. Did somebody ask for a readout?
Could I have all read out, please, sir?
All read out. Yes, very well.
All contra and abstain.
Okay, those members who voted pour were Senators Gorst, Farnham, Falwa, Moore, Pallet, Mezek, Constable St Helier, St Brelard, Grouville, St Juan, St John, Deputy Southern, Grouville, St Martin, Doublé, St Mary, Truscott, Morale, La Hegra, IA, Ward, Alves, Pamplin, and in the separate chat, Deputy Pershard, Constable of St Mary, Constable of St Peter, Constable of St Martin, Deputy of St John, Deputy Higgins, Deputy Labby, Constable of St Clement, Deputy Masson, Deputy Tadier, Deputy Lewis, and the Constable of Trinity. Those members who voted contra were Deputies Martin, Pennell, St Juan, Ash, Gida, and St Peter. And the abstentions were Deputy Wickenden, Deputy Young, Senator Lafondre, and Senator Ferguson.
Very well. Before that changes the business, that ends the business that's formally on the list. There are, however, 2 items still before the Assembly. The first in time is immigration of Ukrainian nationals, a proposition brought by Deputy Pershard, P37. The second, I don't have it physically in front of me, but is brought by the Minister for External Relations and relates to shipping in the context of sanctions. In both cases, the permission of the Assembly will be needed to deal with them at this session. It seems to me appropriate that we firstly determine whether they can be dealt with at this session, then we determine the priority, and if Senator Gorst wishes to ask for a matter to be taken today and the Assembly to sit late, he's in a position to make that proposition once we know it will be dealt with. So the first thing I think is to ask Deputy Pershard to I beg your pardon?
So I don't mind making the case for both, or all 4 arguments in one vote, if you would allow for that.
I'm not sure I understand what you're proposing.
Well, there is a foreshortened lodging period and then the standing order to deal with today as well. But I think we might as well take both propositions in one.
Well, yes, but we must deal first with Deputy Pershard's proposals prior in time.
Sorry, so yes, indeed, that would be a separate decision.
Yes.
I'm happy to make the case that both items should be taken with a shortened lodging period, and that they should both be taken at this sitting if that meets your approval.
Sir. With Deputy Pershard's one as well.
I'll be happy for that too, sir, if that helps.
If you're happy for that, Deputy Pershard, very well. Senator Gorst, if you'd like to make that
Yes, thank you, sir. I'm sure that members will see from reading both propositions they relate to the ongoing war in the Ukraine, the sanctions shipping register regulations relates to the implementation on the register of a sanction order which I made yesterday, and therefore I would like to get it done as quickly as possible, and therefore I think it passes the test. In relation to Deputy Persaud's proposal, a lot of progress has been made by the Minister, and we're all mindful of the announcement yesterday of the UK Home Office. People are right now seeking to cross the border and requiring help in accessing visas, and therefore, so I think that is also meets the test for being taken for having a shortened lodging period, and that both of them rightly should be taken at this sitting.
And do you also include within that proposition the amendments brought by Deputy Masson to...
Indeed I do, sir, yes, yes.
Very well. And so the proposition is that both of these items are taken in a foreshortened lodging period at this session and are dealt with as the next items of business. We will deal with the order in which they're dealt with then. Is the proposition seconded?
Yes, sir.
Does any member wish to speak on the proposition? If no member wishes to speak on the proposition, then I close the debate and open the voting. If members have had the opportunity of casting their vote, I'm sorry, was there some observation on which a ruling from the chair?
I think there's a few of us who missed the fact the vote was open, sir, but we've spotted it now.
Well, that's all right. That's why I leave a long time between actually closing the vote and suggesting I might. But, right.
So, could I raise a point of order?
Yes, you can.
Sir, could I ask for a ruling on whether it's right that we vote for two separate propositions to be shortened at the same time?
Well, the answer is yes, because that's been brought in. You can vote against if you're not satisfied with both, or you can vote for, but that's the way the Assembly's taken it. So I'm closing the voting. The proposition is adopted, 41 votes pour, no votes contre, no abstentions. In which case we deal with both items today at this sitting. Now, is there a proposition to be made as the order in which they should be taken?
There is, sir, but I wonder if you would prefer a proposition around whether they should be taken now or whether we should come back tomorrow morning, because I'd be happy to make the proposition to take them now.
Well, it seems to me, Senator, that your whole point when you last raised the issue was that the importance was to pass it today, if you possibly could, and so that wouldn't require an extension of time for the Assembly to sit. So that would be the appropriate proposition. In the context, if the Assembly sits, it will take both propositions next.
Thank you, sir. You've just indeed made the case for my proposition. I would just say in further adding to that case, that the Minister for Home Affairs and myself will be supporting the proposal of Deputy Persaud and the amendment of Deputy Masson. As I've said, good progress has been made. There will be there will be things that we need to say around our membership of the CTA, of course, which members would understand, and making sure that that is appropriately maintained and we act appropriately. But that should mean so that we can take both items within very little time at all, and could take them today, sir.
Is that proposition seconded?
Yes.
To sit to deal with these items. Does any member wish to speak on the proposition to sit? Deputy Ward?
So can I just some clarity? So we're talking about taking the one on shipping tonight, but not the other one, because there doesn't seem to be urgency on the other Deputy Persaud's proposition to be taken tonight, just the shipping one.
Well, the proposition... Please.
That is the proposition I just made, sir.
The proposition is to take them both and to extend the sitting accordingly. But it's a matter for members whether or not they wish to vote for that or against that, and possibly come up with an alternative in the event the vote is against. Right. Does any member...
Sir. Apologies. May I speak?
Yes.
On this?
I'm sorry. If we just can hold on a moment. It hasn't been. Well, the first thing is the proposition seconded?
Yes, sir.
The first two listed to speak will be Deputy Young and Deputy Pershard, and then Deputy Ward and Deputy Sutton.
So you're calling me now?
I am, yes.
Thank you very much, sir. Sir, I'm a little bit confused. The speed of this discussion has rather overtaken me by surprise. I have no problem whatsoever that we can discuss the shipping measure this evening, because that seems to be and automatically follows on our whole principles of tightening the sanctions and following what the UK does. So I would have thought that would not be a debate that would need take us long in the way we do these things. Absolutely follow the spirit of Deputy Pershard's proposition, but I'd like to hear fully from our Home Affairs Minister and to have, a proper information, sir, about what decisions the UK are doing, what our sister island is doing, to ensure that what we end up doing is all consistent. And I absolutely, go with the spirit of helping, sir. But I am pretty worried about taking Deputy Pershard's as well at 5:30 when we've all had a tiring day. And so, my feeling, sir, is not to do that. But that's only me, and obviously I'm in the hands of others. But I see Deputy Pershard is going to follow me, and obviously I'm very interested in what she has to say.
Thank you very much indeed, Deputy Pershard.
Thank you, sir, and I'm apologising to members for some of the confusion here. I had messaged Senator Gorst to state that I would be happy to wait until tomorrow to have P37 debated in order so that we could prioritise P38, which is shipping, because I had a chance to read it this afternoon, and obviously there's members who read it will understand that there is a implementation kind of urgency if we wish to support it, which is that it is enacted the day after it is voted for. So it makes a lot of sense to prioritise P38 in my mind. I was hoping to just get clarity on members whether the lodging period for P37 could be reduced, which it now has been, but I would prefer to wait till the morning to deal with it, just simply because I have a speech prepared that is in excess of 10 minutes, and I know that other members will want to hear from the ministers to clarify certain things and to give reassurances on certain things, and I think that time is just needed. So I would perhaps suggest, Senator, I don't know if it's possible to withdraw that and reframe it to hopefully match.
That's entirely a matter for the Senator if he wishes to withdraw that.
So indeed, sorry, sir. Indeed, so in light of Deputy Pershard's comment, I will withdraw the request to take both items this evening and simply put forward an amended request to take the shipping register item this evening. Thank you.
I assume members have no difficulty with the withdrawal of that proposition and the substitution of a proposition to take simply Senator Gorst's matter this evening, and that will mean the effect would be Deputy Pershard's proposition will be dealt with as the first item of business tomorrow. Very well, that's been seconded. Does anyone wish to speak on the revised proposition? I'm not sure what Deputy Labby's... sorry?
My apologies,
Deputy Sutton. It's all right, I'm calling on Deputy Sutton.
Yes, and I will be brief. We've just spent 3 hours talking about parental rights, and we're about to go on for an extended session which impinges on parental rights, because our rules say so. And I just find, like time and time again, I have to stand to point this out to people, and it's really, let's stop it.
Does any other member wish to speak? Senator Farnham first.
Thank you, sir. So just very simply put, it won't have escaped members' notice. There is a war in Europe, sir. These matters need to be dealt with as a matter of urgency. If it means we stay on, sir, we should do, because...
Does the Minister think that
important.
votes will be lining up
I'm
outside
sorry.
the Harbour, sir?
Look, occasionally at the end of the day, people forget the rules of debate in this assembly. Let's try and remember the rules of debate in this assembly. Deputy Sutherland, if you have an intervention within accordance with standing orders rather than any other, then please do make it. I think it might be outside standing orders, so please do carry on.
I was going to give way, sir, but I finished what I had to say. So
Very well. Thank you, Deputy Dublé.
So, whilst of course I think the issue of parental responsibilities of members and other caring responsibilities is hugely important, could I just ask perhaps how long the Minister thinks this will take? Because I think if it is going to be under half an hour, perhaps we should, because it's something urgent. I wouldn't usually say that, but as I have said in the past, I do understand for things like budgets and medium-term plans and things like that, we have stayed late. And I think, as one of the ministers said, this is about war, which of course is urgent. So if we could be reassured of the time that it would take, perhaps, then that would help me.
Very well, Deputy Labby.
Well, absolute. I mean, I'm delighted to hear from Deputy Dublé. Turn my camera. I thought this was urgent. I've not looked at it as detailed as I should have done, but I'm going with the flow and the urgency of this because of what is happening in Eastern Europe, and now we're having this debate about whether we should stay on and inconvenience ourselves to put this through. I mean, this is urgent legislation. It's been accepted by you, sir, because it is urgent legislation. Let's deal with it.
Thank you very much. Does any other member wish to speak on the proposition as to whether or not we stay to deal with the proposition? Colin Harbison, one.
Thank you, sir. It's just really to reiterate the point that Senator Farnham made. Let's be clear about this. People are dying in Ukraine, and we need to do everything we possibly can to reinforce our position as a country that we are seriously behind them and we are taking our sanctions seriously, and we need to do this evening.
Does any other member wish to speak on the proposition? If no other member wishes to speak, I close the debate and call upon Senator Gorst to respond.
Thank you, sir. And I do understand the concerns of members around parental responsibilities. Being a parent myself, and so we shouldn't, of course, impinge upon them lightly, and I don't. This is a straightforward amendment to regulations, and therefore, providing members don't wish to speak at length on the matter, it should be a short debate, and I hope approval for it. So I've made the case why I think it should be taken this evening. My comments will be extremely brief, and therefore it's in the hands of members to how long the overall debate is, sir. And I make the case, sir. Thank you.
Very well. I invite members to return to their seats and ask the greffier to open the voting. The vote is on whether or not we take Senator Gorst's proposition in an extended sitting tonight.
I thought the proposition, sir, was we were taking both of these.
No.
Or Senator Gorst changed his mind.
No. What happened, Deputy Pershard indicated she wanted to take us tomorrow. Senator Gorst withdrew the original proposition and substituted for it a proposition duly seconded to take only the one item.
Right. Thank you, sir.
Thank you. If members have had the opportunity of casting their vote, then I ask the greffier to close the voting. The proposition has been adopted. 43 votes for, no votes contra, no abstentions. Accordingly, we now come on to deal with Senator Gorst's proposition, and I ask the greffier to read the citation.
Draft Shipping Registration Amendment Sanctions Jersey Regulations 2000. The states make these regulations under Article 13 of the Ship and Jersey Law 2002.
Senator.
Thank you, sir. As members will be aware, I made by order the access to Jersey ports sanctions to vessels yesterday in order to ensure that the Jersey Register of Ships was also compliant and aligned with the UK sanction. In this regard, we need to amend that regulation, which means that the registrar must, to comply with the sanction, be in a position to be able to refuse a ship to register, terminate the register of a ship, or take other action in connection with registration of ships where they might be in breach of sanctions provisions, sir, and I commend it to the Assembly.
Is the principle seconded?
Yes, sir. Yes, sir.
Does any member wish to speak on the principles? Deputy Morell.
Thank you, sir. And of course, I fully support the Minister in bringing this proposition. By very kind action of the Minister for Economic Development, I have delegated responsibility for the shipping registry. And so when the External Relations Minister asked if I would be satisfied with these regulations, I had one question, which I think it is worth the Assembly knowing what that question was. And the question I had was, what is the effect on the ship, on a ship or its crew, of being deregistered? And so I just thought it would be worth letting you know what the response was. So there is nothing preventing a vessel from sailing if it is deregistered, unless the port in which it is located determines otherwise. The vessel just ceases to have a connection to or support from the flag state. It is in theory possible for a vessel to remain unregistered, but it can cause issues with trading. It is less of an issue with a leisure vessel. If this were to be the course, if a ship was deregistered, the course for the owner would be to possibly find a different flag which is not imposing sanctions, or in this case, to register itself in Russia. So I just say that to aid the Minister in finding the support of the Assembly for this proposition. Thank you, sir.
Does any other member wish to speak on the principles?
Yes, sir. Please.
Constable St Brelard.
Thank you, sir. I think I need to declare interest to the extent that I and my company act as representative persons for a number of vessels, albeit no Russian ones, but as part of the registration process it is necessary for a local person to be appointed as such. And I would just elaborate to members that there may well be large Russian-owned private vessels with representative owners in the island. Thank you, sir.
Very well. Very much. That doesn't disqualify you from voting, of course. It's not a direct financial interest. Deputy Young.
Thank you, sir. I thought I would raise the invite the Minister in the response to let us know if there's any more information that we know about these these Russian-owned vessels. Obviously, we've been seeing for many years about the luxury yachts of oligarchs being registered, and it's been rumoured that one of those is registered in Jersey. I have no idea if it's true or not. And indeed, in fact, during the debate we had, I think it was early on, or during question time, it was revealed that there is I believe that there is known to be local, local financial businesses are handling certain local matters to do with such very wealthy residents. Could I take it that this would allow us to intervene in that situation? I invite the Minister if he's able to give us any more information about that, because the media is full of reports of these Russian-owned luxury yachts fleeing from ports to escape sanctions. So is he able to say anything about that? Thank you.
Very much. Deputy Higgins.
Thank you, sir. I should be fully supporting this measure because I believe we should be taking measures like this immediately rather than delaying. Now, I've sent an email this afternoon to both the Economic Affairs Minister and the Chief Minister about reports that Russian oligarchs, including Abramovich, who I do believe has some interest in the island, including property, is trying to liquidate many of his assets as quickly as possible to withdraw money from the various centres that he's got. So I hope ministers are looking at people like Abramovich and others who may be in the island or have interest in the island and looking to see that they can stop their trying to get liquidity from getting rid of assets quickly and also prevent firms assisting them. Thank you, sir.
Very much. Going to absent one.
Thank you. Thank you, sir. I think I just need to add something to this as somebody who has some experience in these matters. Any ship that is registered in Jersey or in any British port is entitled to fly the British ensign and is technically entitled to protection from the Royal Navy if they come into trouble. So this is why this measure in many ways is important. If a Russian oligarch owned a vessel and it's registered with a British flag, and there are quite a few, for example, in the Black Sea, they could pretend to be British vessels and could get up to all sorts of mischief. So it's important that we pass this today, and the reasons are less obvious than perhaps we thought when we started this debate. So thank you.
Does any other member wish to speak on the principles of the legislation? No other member wishes to speak? Then I close the debate and call upon the Minister to respond.
So I'm grateful to the Assistant Minister at Economic Development, Tourism, Sport and Culture for his comment, and he's right to be concerned about the livelihoods of crews of vessels who are often just contracted and not actually directly connected with the owner. So I'm grateful to him for that. We just must, I suppose, in answer to Deputy Young, remind ourselves that this is about the register and therefore ships that are sailing under the Jersey ensign and ensuring that the registrar has the power to deregister vessels. That's vessels that are in our waters or in our harbour, but more likely elsewhere around the world, and just can simply deregister them in line with a sanction. It was the order that I made yesterday, which has received media attention from a similar instrument that was made in the UK and is now being made around Europe as well, about stopping access to ports and seizing vessels. Those prohibitions come in the order rather than in this particular piece of legislation. That has required a direction to the Harbour Authority, and they are giving effect to that. I'm grateful to the Constable of St Brelade's, of course, a person with first-hand knowledge, and I bow to his knowledge. The information that I have from the shipping registrar is that they have no information to indicate that any of the ships on the Jersey register will need to be deregistered as a consequence of this legislation. They have no knowledge of that. But I remind members of the announcement that I made yesterday that we have set up a local task force to make sure that we are working with all relevant authorities to ensure that all information is up to date, is appropriate, and that they are enabled to take action that needs to be taken in light of the sanctions that have currently been made, but just as importantly, in light of other sanctions that will, I have no doubt at all, be made in the coming days. And that really ties into the comment that Deputy Higgins made, that there are sanctioned individuals, and those individuals and those sanctions are being put into effect. We are working with the United Kingdom on those sanctions and exchanging information which might give him some confidence, but we can only act in line with the sanctions issued, not extraterritorially in the way that he might be suggesting and concerned about. But I would simply say this, that I hear his concern, and again, that is part of the work that the task force is undertaking. So I maintain the regulations in principle. Thank you.
Indeed. I invite members to return to the seats and ask the greffier to open the voting. The vote is on the principles in these regulations. Members have had the opportunity of casting their vote. Then I ask the greffier to close the voting. The principles have been adopted. 43 votes for, no votes contra, no abstentions. Deputy of St Mary, does your panel wish to call this in? Do you wish to deal with the matter in second?
Indeed, I do, sir. I'll take the articles en bloc. They are very straightforward and have a common understanding, I would hope. Thank you, sir.
Are they seconded for
Yes,
second
sir.
reading? Does any member wish to speak in second reading? No member wishes to speak in second reading? Then I close the debate and ask the greffier to pose, I beg your pardon, and open the voting. If members have had the opportunity of casting their votes, I ask the greffier to close the voting. The regulation has been adopted in second reading. 44 votes for, no votes contra, no abstentions. Do you deal with the matter in third reading, Minister?
Indeed, if I may, sir. Thank you.
Is it seconded for third reading? Does any member wish to speak in third reading? No member wishes to speak in third reading. Then I close the debate and ask members, open the voting and ask members to vote. Members have had the opportunity of casting their votes. I ask the greffier to close the voting. The regulations have been adopted in third reading. 45 votes for, no votes contra, no abstentions. Is the adjournment proposed?
Indeed it is, sir. Thank you.
Very much. Very well. The Assembly stands adjourned until 9:30 tomorrow morning.